Hey, good afternoon. This is the matter of Belensky versus Gardner, case number 23023131DM, present in the virtual courtroom. We have both parties along with their respective attorneys. This is a continuation of a hearing on a motion to terminate spousal support and attorney fees that we began on June 5th. There's a stipulation, I believe, regarding an additional exhibit or a completion of an exhibit, supplemental exhibit. I don't know how to call it, what to call it, but Mr. Sherlin?
Yes, Your Honor. It would be another version, a later version of what I believe we used as Exhibit J, report of investigation by Special Investigations Group. And I do need to email that version to the court. I'll copy Ms. Bryan on that email. I believe that was initially Exhibit J.
Okay, Ms. Bryant?
Thank you, Your Honor. The court may recall that I had issued interrogatories to Mr. Gardner, and interrogatory number 3. Interrogatory number 3 is the question where I asked for him to produce a complete copy of tangible evidence obtained by the investigator, including photographs, GPS data, reports. Mr. Sherlin and his client objected to producing that. I filed a motion for an order compelling that information, and we agreed that a complete answer to interrogatory 3 would be provided. That order was entered by the court March 27, 2026, and I'm referring specifically to paragraph 1C, C as in cat, which is the provision that says he had to complete and provide the complete copy of the surveillance report. Following entry of this order, I received a surveillance report, and it is the one that was first disclosed, I guess, as Exhibit J. And it says at the bottom of that report, date prepared July 30, 2025. So relying on that, we proceeded with our hearing. And then, as the court recalls, at the very end of the last hearing, we learned through the private investigator 2 things. One is that they did not provide the GPS data, even though it was specifically requested in the interrogatory. And secondly, we learned that there was an updated report, and the report is actually dated August 25, 2025, not July 30. And I think that's important for the court to note because of the fact that the date August 25, 2025 is long before the scheduled date of this hearing. I appreciate the fact that mistakes are made with regard to things. I get I didn't realize. I'm not asserting bad faith on the part of Attorney Sherlin, but most certainly this report was one that was distributed at least to the client and was paid for, and it should have been produced. And, we look at the issue of sloppiness or we look at the issue of intention. Either way, I did not receive that report in compliance with the court's order. And as the court knows, under the court rule, when someone doesn't comply with the discovery, we can be awarded attorney fees for that, and that's part of our attorney fee claim. My next comment about the report is that it is essentially the same information which the investigator, Mr. Kamenga, testified to. It's the same dates that he already covered in his last testimony. And if you remember, there was testimony that the car was in the Grand Rapids area. And of course, there was also testimony that the same car left and went back to Wisconsin and stayed for a lengthy period of time. That information, of course, is not within the report, only the stuff favorable to Mr. Gardner. So due to the fact that it covers the same dates as information already supplied by the investigator, I'm agreeing that it can come in. But I'm not doing that. I'm not making that agreement without my strong concern and request for attorney fees as a result of the fact that this report was not provided to me in compliance with the discovery request or the court order. And it didn't necessarily put me at a disadvantage because it is the same information, but it's very frustrating that I had to incur the additional fees to, cover additional pages that, I should have been provided a long period of time. So with that, I want to be fair to the court. I don't want to create an appealable error. So I am allowing and stipulating that it may be entered, the new report dated August 25 of 25. It may be admitted in its entirety, but with my strong request for attorney fees because it was not provided in compliance with the court's order.
Thank you. It is admitted and the request for attorney fees is reserved. I guess it's part of what the decision the court will be making.
Thank you.
All right, Mr. Sherlin?
Your Honor, with the admission of the investigative report, I don't have further witnesses.
All right, Ms. Bryan?
Your Honor, I call Ms. Belinsky as a rebuttal witness.
All right. Ms. Belinsky, would you raise your right hand, please? Would you state your name and spell it for the record?
Karen Belinsky, KarenBalinski.
Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Karen, I want to ask you some questions about the information that is contained within the August 25 surveillance report. After our hearing, did you work with me in my office to review all of the exhibits that the investigator has now supplied?
Yes.
And did you also work with me in my office concerning all of the other exhibits that were prepared by and offered by Mr. Gardner, your ex-husband?
Yes.
And with that information, did you work with us to prepare a calendar to outline the dates of the exhibits which show Mr. Dolangowski in the photographs?
Yes.
And is that the document that you have in front of you?
Yes.
Your Honor, may I screen share the proposed exhibit?
Yes, you may. Just make sure there's no personally identifying information on it. That's fine.
Okay. Is it this one? No. Is this the document that we just described, which shows the dates of the different photographs that have been admitted as exhibits?
Yes.
And with regard to the information that's at the top right here, does it show the yellow? Those are the dates of the photographs provided by the investigator.
Yes.
And the green circles are the dates of the photographs provided by Mr. Gardner.
Yes.
And red are the new dates provided by the updated report, August 25, 2025.
Yes.
All right, move for admission of exhibit 19.
As a demonstrative exhibit, Your Honor?
I'm offering this as a rebuttal exhibit.
I don't necessarily have any objection to the exhibit itself. I just, I guess I don't know that the foundation for the dates has been laid.
I already indicated that she reviewed every single one. If you want us to take the time to go through every single one, we could. But I think that doesn't make a lot of sense to do that. You could always tell us if we missed one.
I guess as far as admissibility, Your Honor, I have no objection.
All right, it's admitted. Thank you.
And Karen, with respect to this calendar there's a period of 3 weeks here, 2 weeks in July, 1 week in August, where Mr. Dolangowski was at your house. Is that correct?
That is correct.
And after you saw the updated report, did you go back in your records to figure out why he was there for 3 weeks?
Yes, I did.
And why was he there for 3 weeks?
I had a new litter and he came out to help.
Okay. And was there another event that created a problem which extended his stay?
There was, on the 31st, a tree branch fell on my car and damaged it.
And so why did that mean that he had to stay longer?
I ended up needing a rental and the rental company does not allow dogs or puppies in their cars.
Why did you need to have dogs or puppies in your car?
I have various vet appointments that I need to get to. So in order to get the animals to the vet appointments, I needed to have a vehicle I could put dogs in.
And why was he needed to help you with that?
Originally he was going to go back earlier, but again, I just needed to use the van and be able to get the dogs to the vet appointments.
Now, based on the testimony from the investigator at our last hearing, they tracked his vehicle leaving on August 9 and then returning to your home. And where did he go when he left on August 9?
He went home.
Which is where?
In Wisconsin.
And then according to the investigator report, he returned on August 22 or 23. Why did he come back?
He was returning the van.
Why did you let him borrow your van and go to Wisconsin for those 2 weeks?
I had offered the use of the van for him because he needed the van for a job that had like large lumber and material. So I had offered it to him because I also had a puppy that was going to Wisconsin. So the agreement was he was to transport the puppy, use the van, and then bring the van back.
And then did he stay for a longer period of time after August 23?
No, he did not. He stayed for 1 or 2 days and then he went back home to Wisconsin.
Okay. Additionally, according to your ex-husband, he photographed Jay on some other dates in September, one in October, one in November. Do you have any reason to dispute those dates?
I do not.
Okay. November 25 or 26, he came back. What date? What is the significance of that visit?
That was the day before Thanksgiving.
All right.
I had multiple people over for Thanksgiving.
And he was one of your guests?
Yes.
And then with regard to the Christmas, I think that's December, it's small there, but it's December 25, is that right?
That is correct.
And why was he there?
Again, he came for Christmas and he actually left on the 25th.
Okay. All right. Let me see if I can get rid of this. Then additionally, he testified, he went through all of his photographs in his testimony and he indicated that he had photographs of Mr. Dolangowski. Did you go back and look through those photographs?
Yes, I did.
And were there any photographs which he claimed to be Mr. Dolangowski, of which you would disagree?
Yes.
And what one was that?
There was one where there was a picture of my friend Alex walking across the driveway, and he claimed that was Mr. Dolangowski, and it was not.
Okay, let me see if I can screen share that. So this, I'm showing you exhibit Z-LL. Do you see that?
Yes.
And there's an individual there. Who is that individual?
That is my friend Alex.
And that is not Mr. Dolangowski?
That is not Mr. Dolangowski.
How do you know that's Alex?
Alex is taller, and just from, the clothing.
Okay. When was the last time that Mr. Dolangowski spent an overnight in your home?
That was April of 2026.
And then have you been to his home since April of 2026?
No, I have not.
Have you been to his home since we were last in court?
No, I have not.
Has he been to your home since we were last in court?
No, he has not.
Are you still maintaining a relationship with him?
Yes,
So that hasn't broken up,
that has not broken up.
but he continues to live and reside in Wisconsin?
That is correct.
That's all I have. Thank you.
Mr. Sherlin?
Thank you, Your Honor. Ma'am, why did you need a rental vehicle?
Because my car got damaged by a tree branch.
Well, you have two vehicles, don't you?
Yes, I do.
So you needed a rental vehicle because Mr. Dolangowski had the other vehicle, correct?
The other vehicle was currently at my house, but I still got a rental.
So you got a rental but left the other vehicle, the Honda Odyssey, undriven?
The Honda Odyssey we were using to drive like to the airport or to like the vet office.
Okay, Mr. Dolangowski was using the vehicle, the Odyssey?
Not while I was at my house, I was using it.
Okay, and then where is the Honda Odyssey right now?
Currently, right now, it's at my house.
Okay, when did it return from Wisconsin?
I would have to go back and look at my records. It's been at my house for a bit.
A week or 2 weeks or a month, you know?
I don't keep track, to be honest.
Okay. Um, Your Honor, those are my questions.
Ms. Bryan, any follow-up?
No follow-up.
All right. Any additional witnesses?
No, thank you.
All right. Statements. Closing argument.
Thank you, Your Honor. Would you like me to proceed first?
Sure.
Thank you. Your Honor, I'd ask the court to consider that the totality as envisioned by Smith v. Smith demonstrates that there has been cohabitation. Cohabitation is a terminating event pursuant to the judgment of divorce. I would ask the court to also take into consideration the unpublished case of Herman v. Herman. It's Herrmann. The Court of Appeals number is 306568. Herman talks about the financial dependence between the parties. And I think that's clearly what's happening here. While the parties don't share accounts per the testimony, bank accounts, for instance, or own property together, the financial interdependence pursuant to Herman, analyzing Smith, indicates that that dependence should weigh in favor of cohabitation, Your Honor. And the surveillance period here was a set of information, a subset of information, if you will. The periods, for instance, in the report show from July 11th to August 23rd. The photographs that were admitted into evidence show additional dates where my client, only when he was appearing for his parenting time, had an opportunity to view and photograph Mr. Dolangowski at the residence. We clearly understand that that the plaintiff has the opportunity to date and has the opportunity to be in a relationship. It's really a question of whether these parties are enmeshed to the point where they've changed the nature of that dating relationship to more of a, I guess, a cohabitation. And I was struck by the fact that Mr. Dolangowski testified that he doesn't file tax returns, that he really couldn't state an income, although I think the plaintiff had that same difficulty in terms of stating her income. And we learn as Mr. Dolangowski is testifying that he's really at his son's residence. I think that's what I heard him say. And that he has Ms. Belinsky's vehicle in Wisconsin. And I apologize if I get it right, but I know it was an extended period of time. I thought I remembered hearing a couple months, but maybe I'm wrong. Certainly, I heard it was there for an extended period of time, and the dog business seems to be intertwined. Although Ms. Belinsky characterized Mr. Dolangowski's involvement in the business as a paid employee. I don't think any records were presented to demonstrate that that was a legitimate business expense or even characterized, through a 1099 or a W-2 as income to Mr. Dolangowski. I really think, Your Honor, that the totality shows that the parties really are hoping that my client would simply ignore what was going on and that they would continue to really just kind of do what they wanted. And from the totality of the evidence, I think it shows that they were cohabitating. As far as attorney fees go, Your Honor, my client doesn't have the ability to pay attorney fees. I think that was clearly demonstrated by the proofs. He is paying substantial sums of money to the plaintiff, and certainly that factors into his ability to pay attorney fees. And the required proofs include a demonstration of my client's ability to pay the plaintiff's attorney fees. I would argue even that the plaintiff, I don't know that the plaintiff demonstrated that she has a need for attorney fees either. I think that the information received by the court regarding the plaintiff's income was very intentionally vague on the part of the plaintiff. I think there was testimony offered and evidence offered that there were a number of income opportunities in the form of these puppies that certainly didn't seem to be reflected in the plaintiff's income tax returns. So I'd ask the court to consider that certainly my client doesn't have the ability to pay, but I'm not sure that the plaintiff has the need either. As far as the attorney fees related to the investigative report, Your Honor, I appreciate opposing counsel acknowledging that it wasn't done with ill intent. I simply provided the report that I believe to be the complete report. I think the point is, though, that there was an acknowledgement, I appreciate the acknowledgement that there really wasn't any prejudicial effect associated with the two versions of the report. So I'd ask the court to consider that my client has demonstrated that there sufficiently that there is cohabitation that has occurred and that the spousal support obligation should be terminated. I suppose there's the question of what if the court terminates spousal, when should it terminate? I would ask that it at least terminate at the point where my client provided notice of his request to terminate. I don't know if there's authority that allows the court to terminate at a prior date based on demonstration of when cohabitation may have occurred, but if there is that authority, I would ask the court to apply the earlier date. And I would ask the court to deny the plaintiff's request for attorney fees from the defendant. And also maybe just a reminder that we still have the parenting time portion of the evidentiary that we just scheduled, and that does include my client's request for attorney fees based on the non-compliance with the terms of the judgment of divorce as it relates to parenting time. Thank you.
Thank you. Ms. Bryan?
As I prepared for the hearing today, I spent some more time looking at the Smith decision and was reminded that there are really three categories of examination for the court to consider. The first is the living arrangements. The second is the personal relationship. The third is the financial arrangement. And under each of these categories of the court, of the opinion, suggests that a trial court look at certain aspects of a case. And I think that when you look at the three arrangements, you will conclude as follows. One, what is the living arrangement of the parties? There's no question that Mr. Dolangowski is a Wisconsin resident. And importantly, that is something that Mr. Gardner knew when he filed this motion. His investigator provided him with the same information that this gentleman was a Wisconsin resident. And I think that's important for the court to reflect on, because he knew going in what he was going against, and whether he was just going to roll the dice or not was really up to him. The living arrangements are that the parties do have separate residences. There was no testimony to indicate that Mr. Dolangowski has a key to her residence. There was no testimony to show that he used her residence as a mailing address. There was no testimony that they were sharing household duties as though they jointly owned the house. The most that they have is that when they had a meal, maybe he picked up his dish. That doesn't come close to meeting the threshold necessary to terminate someone's right to spousal support. We go next to the personal relationship. Well, there's no question that my client has a personal relationship, a monogamous relationship with Mr. Dolangowski, and she has every right to do so. If this was just a question of someone dating someone in a monogamous relationship, that would terminate everybody's spousal support. So it's got to be more than that. Was marriage contemplated according to the Smith case? And there's no evidence that marriage was contemplated. They're not interested in that. The Smith case says, did they spend vacations and holidays together? Well, we do know that they try to spend some holidays together, Thanksgiving and Christmas, according to my client's testimony. But much more than that, there's nothing. They didn't go on vacations together. It says, how does the couple represent their relationship to their family, friends, and acquaintances? How did those people view the relationship? Well, again, we have no evidence to help Mr. Gardner on that aspect of this, because my client indicated that she introduces him, her boyfriend, as Dave, not Dave, her boyfriend, or Dave, my husband, or Dave, my common law husband, just Dave. So with respect to that second important factor, really, there's nothing more than she has a personal relationship with this gentleman. The third prong of the Smith case is the financial arrangement of the parties. Do they share expenses? They do not. And Attorney Sherlin has come up with nothing to show that they do. She pays for her own utility bill. She pays for her own mortgage payments. Nothing has been presented to contradict that fact. Do they jointly own real estate together? No. Do they jointly own personal property together? No. Does one party support the other? No. He's had all the opportunity he wanted to look through all of her bank records. Nothing has been shown to this court that she provides support to him. What she has said is that when he transports a dog for her, that she pays for the gas. That's hardly taking care of his personal expenses. And I acknowledge that Mr. Dolangowski indicated that he doesn't file a tax return. Well, what does that mean? Does that, the fact that he wishes, or maybe that his income isn't sufficient to file a return, or he just chooses not to, that has nothing to show any interdependence on the part of my client. but my client showed her tax return. So to make a claim and say, oh, she hardly showed anything with respect to her income is completely untrue. She provided her tax return, she provided her income, and they had every opportunity. They had 90 days of discovery to look into all of that information, and they either chose not to do or they found nothing to show you. So this is not a situation where he has come close to establishing a cohabitation. My client has every right to have a boyfriend and to have her boyfriend stay in her home for periods of time, such as what has been shown to the court. And I hope that the court finds the new rebuttal exhibit to be helpful, because when you look at the evidence that they've shown, there are only 34 days out of 365 days that they've shown that Mr. Dolangowski has spent the night or been at her home. And the biggest period of time was at the end of July and the first week of August, when my client indicated that she was managing puppies and needed help with managing puppies. This is kind of ridiculous that we're here and that we're even having to argue these issues. The reality is that these, my client and her boyfriend have distinct financial independence. They have separate residences. They live in different states, which, by the way, is exactly the facts of the Smith case. We already know that someone having regular sleepovers does not satisfy the standard of dwelling together. There is no economic partnership, and spousal support is based on need, which she needs desperately in order for her to continue and financially support herself and the two children. There are no sharing of debts. There are no buying of assets together. There is no financial dependence that has been demonstrated by the plaintiff at all. And it's his burden to do that. No sharing of accounts, no sharing of expenses. Now, I heard a comment by Attorney Sherlin that somehow the dog business is intertwined. Well, we acknowledged that her boyfriend has helped her transport a dog. That's hardly intertwined. That's not any different than someone else with a small business turning to a friend to help out here and there, and that's what she needs to have. And when you look at her tax returns and look at how little income she has, you can appreciate why she would need to turn to a friend, whether it be a man or a woman, to help out. I want to go to the issue of attorney fees. As the court knows, I filed an amended motion to distinctly lay out all of the reasons why we are entitled to an award of attorney fees. And we are relying on the claim that Mr. Gardner has substantially more income than my client. And by the way, it's income, not assets. We have an agreement that he owes her a property settlement, and we know that he's got to make those property settlement payments. Those are her assets. And if she's asked to pay for the extensive attorney fees that have already been incurred in this case, then he's got to contribute to that because he has more income than she does. And I believe I recall that in my cross-examination of Mr. Gardner, he agreed that her income, just looking at income, is about, I think it was 10% of his. So to come in today and hear an argument, oh, he doesn't have the income. He does have the income. It's right on his tax returns. And that's what the court is required to look at when assessing the request for payment of attorney fees. So we would ask that the court grant the request for a payment of attorney fees. I know that another hearing needs to be held as to the reasonableness of those fees, and I know that we haven't addressed that. I think that's a second step in terms of the reasonableness of fees. We're prepared to show the court that the fees that she has incurred are reasonable, particularly the work that we've had to go through in order to get the plaintiff, the defendant rather, to simply answer straightforward interrogatories and exercise good faith by giving us complete documents. So I would ask that the court reject the claim that my client is cohabitating and award her the actual attorney fees that she has requested as set forth in the prior exhibits that we've admitted.
Thank you. Mr. Sherlin, did you have any rebuttal?
Very briefly, Your Honor. I don't know that I referenced that my client doesn't have income. I specifically argued that he doesn't have the ability to pay based on the circumstances as they were laid out in the proofs. But Your Honor, I'll leave the court with this. I understand the most recent exhibit that we entered today. And I look at the highlighted portion. I understand that testimony to mean Mr. Dolangowski was present from July 20 to August 9. I believe that's what I heard. And he was there with the stated objective of helping with the puppies. So if that information is correct, if I understand that information correctly, that means that there was this extended period of time that he resided at the home and that he was there to help with the puppies. To me, Your Honor, that's intertwined. Thank you.
Right, thank you. As a housekeeping matter, first of all, I am going to take this under advisement. And Mr. Sherlin, we still need your exhibit.
I was trying to do that while we were working on this, Your Honor, and I'm not that great at multitasking.
That's okay. I'm glad you didn't disconnect yourself. So
Okay.
yeah, if you could just send that over as soon as you
I
can.
will do that as soon as we leave the hearing.
All right. Anything further?
No, thank you.
Okay.
No,
we're adjourned.
thank you, Your Honor. Thank you.
All set?
All set.
Thank
Go
you.
ahead.
Good afternoon, Your Honor. We are here for a review hearing in the matter of Riley Briggs. Present in the courtroom today, we have Riley via Zoom with his mother, Sarah Briggs, and his father, Cody Briggs. We have his attorney, Mary Golden, and myself, Juvenile Probation Officer Jeff Love. Thank you.
All right. Good afternoon again, Mr. Love.
Well, this is a new to me family, certainly not new to probation. I've looked back through, his file, looked back through his notes, through past reports. I mean, it's pretty clear substance use, mental health is still very much at the forefront as much as it has been. It looks like there was a SUD assessment done by Michelle Anguiano that only lasted a couple sessions, and then she was suggesting a higher level of care because in active use, there's not really much that she can do. It also appears to me that it was the family, and if I'm wrong in this, I apologize, say the family decided to remove themselves from the juvenile treatment and support court. So I'll be honest, I start every kid kind of with a clean slate, but it's become very apparent very early on that substance use is still a big struggle for Riley. Mental health issues certainly a concern. They're a wonderful family first and foremost. Engaging, care about their children. They are, really kind of give him everything he really needs overall. But right now his mental health is struggling. And there are certainly some mental health concerns, with the family as well. I know sister just recently moved. She's gone on a mission trip, and that they're very close. So that's been a big change for the family. That's been taking an effect on them. And while she's out chasing her dreams and doing great things, it's still hard to take when your kid is that far away. So that's been an issue. Riley had a clean drug screen. He's had he had a dirty drug screen just recently. I think that there are times that he's able to get himself sober. I don't think that those times are far enough in between to really make any difference. Summer school, he's been doing that, but if I say that average at best is his participation, I might be a little bit gracious. There's been a couple times I've tried to see him up there. He just hasn't been there. They're really hard to get a hold of in the summer. to figure out kind of what progress is. It's a pretty Wild West campus there during the summer. It's pretty sparse. But just based on the effort and the times that I've been there and he hasn't, I can't imagine, that he's doing too well in those courses. So, we kind of continue down the same road. I'm willing to work with him in the community for another 60 days just because he's new to me. But I'm getting closer to the fact that I'm looking kind of towards what Michelle was seeing, in that unless he's able to get his substance use under control, we're gonna be looking at a higher level of care at that point. The drug screens that Miss Nikedra did, I mean, there's a lot, and they're probably 95% are dirty. So there just hasn't been a real solid effort long term for him to be sober. So with that said, right now I'm willing to continue to work with him in the community. We do have school starting up back soon. And I would like to, see him get in and do well. So I would, make the recommendation this time that he remain in the community with his parents, that all previous orders remain in effect, and that we come in back in a little sooner of a time in 60 days and see how he's doing. And I'll be honest, if there's no improvement in that time, I will be looking and possibly recommending a higher level of care, potentially out of the home. Thank you, Your Honor.
Thank you. Ms. Golden?
So, Mr. Love, you're talking about out of the home, you're talking about a residential, correct? Like a substance abuse residential program?
Well, that's a possibility. Unfortunately, our substance use treatment for this county is pretty non-existent, especially for the level of care he needs. So that then leaves residential. If there were a intensive outpatient that I could find, I certainly would support that. I'm looking for it right now and I can't find it. So that's the only concern.
Yeah, and that was my next question. You haven't been able to find an intensive outpatient program?
Not anything that would be suitable. There's some outpatient through Wedgwood right now. It's all filled up. There's nothing available in IOP. Nor do we really have a real good option for IOP right now.
Okay, and what about, I know it says in the report he was referred to Marvin McKenzie. Did he actually meet with Marvin?
Yep, he meets. I'm sorry. Yes, he meets with Marvin regularly, and they seem to have a good relationship. I know that Marvin talks to him about his issues with his substance use and his mental health issues, which is helpful. But unless we start seeing results, we might have to pivot to a different plan.
Okay, so Marvin is able to address both substance use and mental health.
He is, in a general sense. I don't know if he's specifically licensed for like S2D, but from a
Okay.
Therapist standpoint, he certainly can address it in a general sense.
Okay, and is Riley taking any medication right now?
Oh, I'm going to defer to Mom because I know that that's been changing. So I would defer to his parents to just kind of give you an update on that.
Okay, all right, thank you. I have no further questions for Mr. Love, Your Honor.
Hey, Ms. Briggs or Mr. Briggs, if you would unmute.
Yes, ma'am. He's taking hydroxyzine in the evenings. His sleep has been a constant struggle. We've been trying to work consistently with the doctor. He has another appointment next week. He was recently tested for ADHD, and we've been trying to work with the insurance company and the doctor on that. They wanted to put him on what, Cody?
Amphetamine derivative.
An amphetamine derivative, which insurance didn't want to cover, and we're not really comfortable with that. So we're hoping this next week to have that appointment with the doctor to talk about some other options, which should hopefully help him with concentration, with the school, and all of that. Right now, though, he's just taking lemon balm and hydroxyzine regularly for in the evenings to help him sleep and with anxiety. And then he's been taking a couple supplements in the mornings, just a multivitamin and some saffron turmeric, which seems to really help him also.
Okay.
Right, would you respond to the recommendation, please? Ms. Briggs?
Your Honor, oh, Ms. Briggs, okay, sorry. Yep.
I agree with the recommendation. I've seen progress with Riley, but there's definitely still a struggle with the motivation. Yeah.
Okay. Mr. Briggs, anything you'd like to say?
Just that I think he's trying really hard, and I'd like to see him be able to do this.
Okay. All right, Ms. Golden, or actually, Ms. Riley, anything you'd like to say? Sorry.
No, not really.
Okay. Ms. Golden,
Um,
sorry, did you want to say something, Riley?
no, never mind.
Okay. Ms. Golden.
Your Honor, I do support the recommendations, given all these things that are going to be happening in the next few weeks about medication changes, perhaps, them meeting with the doctor. I would ask the court to give him 60 days to see if he can turn this around. Thank you.
All right, thank you. The court finds the recommendations are appropriate. However, the court is going to shorten the timeline to 45 days. The court has been very familiar with Riley and JTask and has worked, closely, seeing him almost every week for months. And we're the same place we were at the beginning. Substance abuse has been an ongoing issue. Riley does better and then he does worse, and he's really never been able to hold a consistent negative record of testing for any length of time. And it's pretty clear to the court that he needs more intensive treatment, but I'm willing to give him 45 days to see where we are, but the next step is definitely residential placement. So I'll continue Ms. Golden as the attorney in this matter, and then Ms. Miller, do we have a date for about 45 days out?
Yes, we have Tuesday, September 1st at 11:30 a.m. via Zoom.
Yes, that will work for me.
Okay, we will see you then, and I hope to see or hear about a bunch of negative screens and that you're doing better, Riley.
All right.
Anything further?
Can you repeat that court date one more time?
September 1st at 11:30.
All right. Thank you. Appreciate you.
All right.
The 1st of July, and we're here. We have a number of settings with us, so I will start by calling the docket. When I call your case, just let me know that you're here. If you would confirm your time announcement, or let me know if it's going to be shorter, and confirm that you need a record or not. First up is McBride versus McBride.
Your Honor, petitioner's here and ready. It's a default. I anticipate 10 to 15 minutes, and yes, we would like a record.
Thank you. All right, next up is Ziefman versus Ziefman.
Morning, Your Honor. Chris Alvarado with my client, Audrey Duff Ziefman, who's here. Miss Ann Wynn's also here. We called for 3 hours, and I would confirm that.
Good morning, Judge Michael Burnett and Ferris Young here for Clifford Ziefman. There's supposedly 3 different motions set today. I am going to object to a hearing today on respondent's motion for interim attorney's fees. We received their motion after we agreed on this setting, and I've never received a proper notice of hearing on their motion for interim attorney's fees. The other problem I have with it is if we're going to take up the property motion and my motion to bifurcate time, in addition to the motion for interim attorney's fees, we would need longer than 3 hours today. But I am here and ready to go forward on their property motion and my motion to bifurcate. And I expect those 2 motions will take 3 hours.
Okay. We can talk about those other issues later, but for now, I will put y'all down as 3 hours and needing a record. All right. Last we have Grizzle versus Seals.
Yes, ma'am. Steve Campos for the petitioners. This is an uncontested temporary orders hearing. We're still processing the adoption termination paperwork and coordinating with the guardian ad litem, who has not yet been done the order for this, but we set this because the parties have register the child for school, and they've had the child for more than 6 years now, and so we're just kind of getting around to getting all of this done. So we're going to have a maybe 10-15 minute hearing.
Okay. Are you expecting either of the respondents to appear?
They were here, and they just texted me that they're rebooting because apparently their computer shut down, and so they're connecting. But they were just here just a moment ago.
Okay. Who are your clients?
The Grizzles.
Okay.
And both the biological parents have waived to notice that in the affidavit of relinquishment and the affidavit of waiver of service, interest in the child. Both parents waived their right to.
Okay. So
attend
we're not expecting Mr. Seals or Miss Teeton to appear.
That's correct.
Okay. All right. Thank you. I appreciate it. Okay. We are going to start with McBride versus McBride. So if everyone else would go ahead and turn off their video so I can just see those parties. We'll take up the uncontested matter on Grizzle next, and then we'll get to the longer hearing will be last. Any questions? All right. Thank you. Okay, we are here this morning on cause number FM 25-007821, McBride versus McBride. Counsel, you may proceed.
Your Honor, Larry Shuba Jr. and I'm representing the petitioner, Miss Jennifer McBride. We're here for a default on a final on a divorce. And we're ready to move forward today. I believe that we have filed and or uploaded every document as needed, certificate, last known address, all the soldier information as was all filed yesterday. Just a brief background. The evidence briefly that Judge Matthews Rodriguez had heard back in January when we got temporary orders. The father has had a long history of alcohol and drugs, unfortunately around the kids, and unfortunately became very unstable. And we went in front of Judge Matthews Rodriguez back in January, where she granted Miss McBride to be temporary sole managing conservator, ordered Mr. McBride to have supervised access through an agency, or if Miss McBride would do it, and you'll hear a little bit about that she did try to do 2 or 3 times. Also for him to do pretty intensive drug testing and some battered intervention program. He's done nothing. And we don't know that he's a horrible person. He's just got a bad issue with drugs. And so she's moving forward today. We are asking that she be you grant the divorce and that she be appointed as sole managing conservator. He's a possessory. The visitation is outlined in both our proposed disposition of issues and more specifically in the order that we've uploaded that we would hope for you to sign today. Also to we've essentially taken all the temporary order language on the testing and all the things that he needs to do in order to get back with his kids. You're going to briefly hear that she tried to have a couple of times. The only thing he seemed to be mostly worried about was either showing up at the home unannounced or trying to get a gun back. So she's been very concerned about that. So we've awarded her there's a rifle and a gun, and we've awarded her that, and also have some separate property that she's awarded. And then the only other thing that's different, and then I'll be introducing a spreadsheet, is that she is being awarded the house. The house has a lot of issues, and it's going to take a whole lot to ever get it to be able to sold. We have an equalization that she is going to pay to him to even up. There's not a lot of assets other than that. They've gone through all retirements, everything that's out there. There's just not much money left. My client makes about $4,100 a month gross. It's been a very, very, very hard, long battle for her. As far as what we're going to be asking for today, she has been on chips. She's had the kids on chips. She's going to continue that. However, he is there's been a little hiccup on it, but she's going to continue that process, and she would be responsible for that. She does have dental insurance available that she's also having. And Your Honor, we had the child support that was ordered was a very minimal amount. Unfortunately, we tried to base it on what we think his last job was, but we have no knowledge. We have no information. We don't even know where he's really living right now. But we think he's working because he seems to always have money, always be driving a car. I don't have a lot of information. Judge Matthews Rodriguez had set it at 445 for 2 kids. He hadn't paid that, so I don't know that it's going to be real money either way. So we are going to be asking for child support, and I think we have a touch of reimbursement for some dental insurance or the chip insurance. And then ultimately on our spreadsheet, there's not a lot of assets, but she's asking to keep the house with an equalization payment. And with that, I'd like to bring Ms. McBride to the stand.
Okay. Ms. McBride, would you please raise your right hand and be sworn? Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
And please state your full name.
Jennifer Rochelle McBride.
And Ms. McBride, you're currently married to Draper Scott McBride.
Yes.
And prior to the filing of this petition, had you or him resided in Travis County, Texas for at least 6 months?
Yes.
Has your marriage become insupportable due to discord or conflict?
Yes.
Is there any reasonable chance of reconciliation?
No.
Y'all have 2 children born to this marriage, is that correct?
Correct.
And what are their names and ages?
Zayden McBride, he's 11, and Eden McBride is 9.
Okay, are you pregnant, or is there any other child that you're aware of that's been brought into this marriage?
No.
Okay. And we are going to be asking the court to grant a divorce today. Is that correct?
Correct.
Okay. And through a default process, he was given notice. He's never showed up to anything, and he's never done anything he's been ordered to do. Is that essentially correct?
Yes.
So just briefly for the court, briefly describe the drug situation and how that impacted your kids.
Well, he is a recovering alcoholic, and he is using drugs. It got so bad to where he would become violent and threatening to me in front of the kids. And then the last straw was finding drugs in my son's room.
Okay. Now, since we went to court in January and you were appointed as temporary managing conservator and he was not awarded any visitation other than through an agency or through your supervision, has there been attempts that you've allowed him to see the children?
Yes.
And about how many times?
About 4 or 5.
And is just again, very briefly for the court, how did that go?
Not so good.
Okay. Did you meet him in a public place?
Yes.
Okay. Now, as part of this final decree, we're asking that you be appointed as sole managing conservator. Is that correct?
Yes.
Is that because of both domestic violence situations between you and him and with the issues that he has created in your household with your children? And your children have suffered from this greatly. Is that true?
Yes.
Okay. Now, our the visitation that we're asking for is to be either through an agency in a step-up situation or by you, because out of the goodness of your heart, you were trying to let your kids see him. Is that correct?
Yes.
Okay. And would there be any, well, I'm sorry, briefly for the court, what was the worst issues when you did go to meet him with the children?
He became violent because I didn't bring his guns, and he started cussing and yelling loudly. And that just, obviously that wasn't good for the kids. So.
Okay. Now, we have filed proposed disposition of issues, and let me try to pull this up real quick. of course, I'm struggling a little bit, so excuse me. Your Honor, I may need help pulling it out of the box. I was going to pull the proposed disposition of issues in the property division spreadsheet, and I'm not seeing my
Okay. On the bottom
exhibit
of your
listed there.
screen, there's a button, a green button for share.
Yeah, I've got that, but for some reason, I'm not able to click on what I'm wanting to do right now. Let's see. I had it going earlier. Sorry.
That's okay.
There we go. Miss McBride, would you briefly describe what's been marked as Exhibit P002?
Okay, we're not seeing it on the screen.
No.
We're seeing an email. So if you have 2 screens or 3 screens at your office set up, you're going to need to select the right one when you're
I'm on my laptop and that's all I have, and it shows up on my screen. I'm sorry. Not even sure what else to hit now. It says you're screen sharing, stop share, start again. Um,
Okay, we see it now. Go ahead.
Okay, good. Ms. McBride, briefly describe what's been marked as P002 exhibit.
This is like the orders.
This is the proposed disposition of issues for our final orders. Is that correct?
Yes.
And this was prepared by us with your help. And do you believe it to be true and correct?
Yes.
And are we asking for the court to award you for instance, we've asked you to be appointed as sole managing conservator. Do you understand that?
Yes.
And Your Honor, I'd like to offer exhibit 2, my first exhibit 2.
2's admitted.
And then Miss McBride, if I can do this one now. Stop sharing. I'm sorry, Your Honor. I have a spreadsheet that is part of our pre-trials that's in the box that I don't seem to be able to upload right now. I don't know if the court can take judicial notice of what's in the box and I can introduce it from that.
Why don't you just offer it? I have access to it, but you can just offer it.
Miss McBride, as we had talked and reviewed earlier, I believe it's exhibit number 3 is our proposed division spreadsheet. Do you recall that?
Yes.
And would you like that to be offered into exhibit as exhibit 3 offered into evidence?
Yes.
And do you believe it to be true and correct to the best of your ability?
Yes.
And this is where we're awarding the assets and debts as you currently have them. Is that correct?
Yes.
You have a house, but the house is not worth as near as much as it used to due to market forces and to severe disrepair. Is that correct?
Correct.
And you have not had the money nor the help from your husband to help fix it?
Right.
Do you believe it would be in the best interest for the children to remain in this house?
Yes.
And we do have a equalization that you'd be paying your husband. Is that correct?
Yes.
And the rest of the division is just some bank accounts that you have and some separate property that you brought into the marriage that's reflected on this spreadsheet. Is that correct?
Yes,
And do you believe it would be this division is fair and just?
yes.
Your Honor, I think that's all I have unless you have any other specific questions. I think it's the proposed order that we have is outlines it traces most of what Judge Mendoza Matthews Rodriguez did, and I would like to urge the court to grant this. It gives all the rights and duties under 153, 132 that Judge Matthews Rodriguez had also ordered, and it's just we just basically took that order and made it into more of a final order. And I think that we urge the court to grant the divorce and sign this order.
Okay, and just for the record, that last exhibit was P3?
P3.
Okay, that is admitted. And is there a request for a name change?
There is not a request for a name change, Your Honor.
Okay. Okay. And
we have an order that's in the box that again, we're open if you have any issues with it, but we tried to track what Matthews Rodriguez did and put everything that's normally included into our order.
okay, and just maybe if you would just review the child support provisions with me.
Yes, Your Honor. Again, the only information, we do not have any specific information regarding his employment right now. We do know that he's doing odd jobs and working. We don't know anything else. Based on that information, the previous child support was set at $445. Again, he's not paid it and he's not reimbursed any money, so I don't know that it's going to be a real number anytime soon anyway. Miss McBride is definitely struggling. It's been a very big hardship. I'm not asking for attorney's fees because they would never be paid, of course. But I believe that the minor amount that we have in there is the best that we could come up with a guess based on what his current lifestyle is. He's driving a car, he's getting around, he's doing things, he's meeting people. We think he's just doing odd jobs, but we don't have an actual place of employment.
Okay.
And I can ask that again from Ms. McBride to confirm that.
That's fine. You can go ahead and get that confirmation.
Ms. McBride, is the best of your understanding, you do not know where he's employed.
That's correct.
And you don't even know that he has a job, that you believe he's working based on what he's doing with spending money and getting around town.
Correct.
Okay. Nothing further, Your Honor.
Okay. Okay, just give me a moment. I'm trying to locate the final decree that was sent in. Okay, here it
I
is.
think it's P6.
Okay.
And just to confirm, Ms. McBride, you are not asking for a name change, is that correct?
That's correct.
Okay. All right. I will grant the divorce on the grounds of insupportability, and I will enter the decree consistent with what we have discussed here in the virtual courtroom this morning. Ms. McBride will be named as the sole managing conservator of the child, and possession and access will be limited as set out in the proposed disposition of the issues, along with the proposed injunctions, and will find that the proposed property division is a just and right division of the community estate. I will enter the decree. And do we have the BVS form?
I believe it was either uploaded or it was filed, but we do have a BVS form.
Okay. If you could email that to Ms. Seeger, that would be helpful. She does not have it, And box is really for the court reporter. So
Right.
if you wouldn't mind sending that to her, we'll get
Yes.
it taken care of.
Absolutely, Your Honor.
All right. Seeing nothing else, y'all are excused from the virtual courtroom, and have a great day. Best of luck to you, Ms.
Thank you.
McBride.
Thank you, Judge.
All right. Take care. All right. Next, we're going to move to our other short, uncontested hearing on Grizzle or Grizel. I'm not sure.
Yes, Grizzle, and there they are.
Okay. All right, let me go ahead and call the case. We're here on FM 24-009047, Grizzle versus Seals and Teton. Mr. Campos, you may proceed.
Yes, ma'am. Your Honor, I'll just give you a rundown of this case has been on file for a couple of years due to a number of factors why it's just now getting to that point of getting concluded and getting the guardian ad litem's off resolved. But they will be involved here very soon and submit the order. But in the meantime, the Grizzles need some orders, temporary orders, to be able to register for the child who turned 14 today. So, and the Grizzles have raised her basically for most of her life, or at least cared for her before they finally 10 years ago got possession of the child. So it's been at the end of this month, it will be exactly 10 years that they have had full-time possession of this child. And so why we're asking for these temporary orders for today. And as I mentioned earlier, both the biological parents have signed an affidavit. Well, in the case of the mom, she signed an affidavit for voluntary relinquishment of parental rights, and the father signed an affidavit of waiver of interest. And in there, they both designated the Grizzles to serve as managing conservators and for to adopt this child, Marley. And in their respective waivers, affidavits, they waived the right to be served and the right to appear for or be notified of any hearings. And those have been e-filed, and I did upload them to Box, but because they're e-filed, and I can certainly ask the court to take judicial notice of those, and don't know that the court needs to have those submitted to as evidence for this hearing. The petition, the petition has the temporary request for temporary orders, and in our draft of the order for the temporary orders for today, I provided the quotes from the affidavits to take notice of that those that's the language from the respective affidavits of the biological parents, and why it's not necessary for them to have notice of today's hearing. And so we are asking simply that the court appoint the Grizzles as managing conservator of this child, May Teton, and that we've just listed all the rights so that they can have the right to make medical consents and to enroll the child in school, etc. And so I call the Grizzles as witnesses, but because it's uncontested, I don't know how much you want to hear in terms of evidence from them. I can give some basic evidence for them so that the court knows that they have had the child for more than 10 years and have cared for the child because they cared for her before she was left in their possession for the purposes of adoption.
Mr. Campos, I'm having a hard time with your audio. You seem to be cutting out constantly. Is anyone else hearing that too?
Yeah. Yeah, we agree.
Okay, yeah, Mr. Campos, I don't know if you want to exit the Zoom and try and rejoin, or if you have a different device.
Let me try that with a different device and I'll see if that makes a difference.
Yeah, it's very hard for my court reporter to, she and I are both struggling.
I apologize. Okay, I've connected through my phone.
Okay, we're admitting that device. Yes. Okay, let's see if that works. You'll need to unmute the iPhone if you want to try and use that for audio. It seems to be. Okay. How about this?
That's going to work for me if that works for you, Jan.
That is much better. You can just disconnect from the other device if you want.
Well, why don't we do this? Why don't I stop the video?
Okay, that would be helpful.
And then you can hear me and look at me more professionally than in this office here.
Okay. Who do you want to testify first? I guess I can swear them both in and then we can proceed that way.
And I'll have, that's fine. And I'll have Rayanne Grizzle testify first.
Okay, folks, if you would just both raise your right hand for me. Do swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth.
Yes.
Yes, we do.
Okay. Go ahead, Mr. Campos.
Ms. Grizzle, let me go ahead and start with you. Is it correct that that Tricia, the mother of the child, Tricia Leanne Teaton, that she placed the child, Marley May Teaton, in your possession approximately 10 years ago for the purpose of you all adopting Marley?
Yes.
All right. And today she is turning 14 years of age. Is that right?
Yes.
And prior to 10 years ago, when you started having full-time possession of Marley, did you help care for her during the 4 years prior to her being placed with you permanently?
Yes.
And is it correct that Marley that you contacted and we contacted the person identified as the father of the child, Christopher Lee Seals? Did we do that?
Yes.
And is it correct that both Miss Teaton and Mr. Seals signed affidavits relinquishing their interest or their rights to the child, and that they waived any notice of any hearings in those affidavits?
Yes.
Okay. And is it correct that you are seeking the temporary orders today so that you can would be able to enroll the child, Marley, in school and to be able to deal with medical issues that may come up without any complications, because you only have the affidavit of relinquishment until now? Is that why you're asking the court for temporary orders?
Yes.
Okay. And is it correct that how long have you and Mr. Grizzle been married?
31 years.
And how many children do you have other than
Marley. 4,
Marley?
5, including Marley.
Okay. And Do you believe that it is in the best interest of Marley that you and your husband be appointed temporary managing conservators until you are able to complete the adoption later hopefully this summer, but perhaps it may be into the fall?
Yes.
Okay. And I think that's all I have for you, Mr. Grizzle. You've heard the testimony of your wife. Do you agree that all of that is true and accurate?
Yes, I do.
All right. And do you also agree that it would be in Marley's best interest that you and your wife, who've been taking care of her for more than 10 years now, and that she's lived in your home now for the last 10 years, do you agree that that's in the best interest that you be appointed temporary managing conservators over her?
Yes, I do.
All right. Your Honor, I think I passed the witness. If the court has any questions for them directly or.
Okay. So Marley's going to be in middle school, I take it?
Starting high school, 9th grade.
Starting 9th grade. Okay, great. And how's school going for her?
We got her out of middle school. That's the most important. Hooray for us as a family here.
Yes, those are difficult years. All right. I don't have any other questions for you. Thank you for your appearance here this morning in the virtual courtroom. Mr. Campos, I don't have any questions for you. Let me just pull.
Temporary order is submitted. I understand that Ms. Seeger forwarded that to you, so you have that.
Yes.
I also uploaded it to Box, but I understand that that's, from what you just indicated, that's more for the court reporter. I don't know if you need.
Yeah, we don't need to enter it as an exhibit.
Right.
Just need to review it. And sorry, I have my many screens, so just give me a moment here. Yes, and I'm looking at the final version, which is noted as, quote, corrected.
That's correct.
I think we had an edited version. Okay. I don't have any questions for you, Mr. Campos. The court is going to enter the temporary orders, and you can go from there as far as setting the adoption for a final hearing, but the temporary orders will be entered and sent to the district clerk's office.
Thank you very much, Judge.
Okay. Any questions for me?
No, Your Honor.
Okay. All right. Best of luck with the finalization of the adoption. And with high school, y'all are excused from the virtual courtroom.
Thank you. Your Honor.
Okay. And let's see where we are. We are going to move on to our final and contested hearing. I'll go ahead and call cause number FM 25-006273, Ziefman versus Ziefman.
Good morning, Judge. My name is Michael Burnett. I represent the petitioner Clifford Zeitman, along with my associate Ferris Young.
Good morning, Your Honor. Chris Laborato. I represent Ms. Audrey Seidman, and I'm here with my partner, Ann Wynn. We're ready.
Okay.
Your Honor, if I can say something, while we've been waiting to be called, my office was able to locate an amended notice of hearing, so I would withdraw the objection that I made in the opening. I still have reservations about whether or not we can finish everything in 3 hours, but I no longer have an objection to lack of notice.
Understood. And let's just review that. It looks like my notes on the docket indicate that we have a motion to compel, a motion to bifurcate, and then a request for interim attorney's fees. Is that your understanding of what is at least set for today?
Yes, and while we've been on a break, Respondents Counsel informed me that they agree with my motion to bifurcate the proceedings. So I'm going to circulate a proposed order, and hopefully we'll have that to you later today.
Okay. As
That's
long
true,
as
Judge.
great. Thank you, Mr. Laverato. So Ms. Seeger can get it to me. So that takes us to 2 issues for today. All right. And are we ready then to proceed with openings?
Yes, Your Honor.
Okay. And let's see. I guess both of the remaining motions are the respondents. Am I correct on that?
That's correct.
Okay. So then you may proceed, Mr. Laverato.
Thank you, Judge. May it please the court. Your Honor, as a matter of some background here, first of all, I know that Mr. Burnett submitted a legal memorandum in opposition to our motion for interim fees. That goes over some of the background of this case, just factually. But so the court understands, this particular case involves the 2 parties here before you who've been married twice. Okay, they were married once in December of 2021, and then they were divorced and then married again in December of 2022. Okay, prior to their marriage, they have several children. My client has 3, 2 of them are minors. Mr. Zeitman has 8 children with other biological parents. There's a prenuptial agreement that existed in both the first and the second marriage. We have alleged and claim in this particular case that prenuptial agreement specifically related to the second marriage is unenforceable, and we've cited that in the first amended answer and the counter petition. That is going to be decided on a later date. We've just bifurcated, and that will be that issue. During the marriage, Your Honor, both marriages, the parties lived together most of the time in what's known as the compound here in South Austin. Okay, actually commonly referred to as the clown house because there's these 2 big pictures of clowns on the side of a barn near an elementary school. Anyways, they lived on this particular compound. When they were not together, all of the items that we're going to talk about today stayed at the compound or another building known as Medical Parkway, controlled by Mr. Zeitman and only Mr. Zeitman. The estate, let me just call it that way. The estate is likely worth hundreds of millions of dollars in this particular case. Again, the issue of enforceability of the prenup's not what's before you. We're not asking you to divide any community property or property belonging to the alleged community. At the core of this motion, Judge, really, it's about establishing fairness and equal footing. Because on the one hand, Mr. Zeitman has essentially unlimited funds to pay for his attorney and essentially defend that this particular prenuptial agreement is enforceable. On the other hand, my client has virtually no resources to do that. It's been no spousal support or no other source that Mr. Zeitman has provided to my client. And so basically, she's on her own having to prosecute and make these claims regarding the enforceability of a prenuptial agreement without any resources, to the extent that she owes our firm at this point over $140,000. She's paid 70 plus. Okay, with regard to the personal property we want returned, I have to show you 4 things, Your Honor. Number 1, I have to show you that the property was owned by my client and was her separate property in some way, whether that be by gift, inheritance, but that she owned it. And the evidence in this case is going to show that she did have possession, she did own these items, and that she was either given these items or owned them prior to marriage. Number 2, I have to show you that she possessed those things at some point in time, and the evidence must show that she did. And there will be my client testifying to that, and also her daughter, Vivian, who's here as well. Number 3, I have to show you that she lost possession of them at some point. And in this case, the evidence will show that they, more likely than not, ended up with Mr. Zeitman. They didn't disappear. They remained at the last location they were seen, which is either going to be at the compound or Medical Parkway, where now Audrey, my client, has absolutely no access to. And Mr. Zeifman has full control over those premises. And then finally, number 4, she no longer has access to get back to them for all the reasons I just stated. She does not. I don't think that there is going to be any dispute that Mr. Zeifman has exclusive possession and control of these pieces of property that I'm talking to you about. And I don't think that there's going to be much dispute that he was the one that really safeguarded the items that we're going to be talking about at some point with regard to putting them in safes or securing them at the locations that he has control over. If you believe, Judge, more likely than not, that she owned these items, that she possessed them, and then at some point Mr. Zeifman had control over them, then we ask that you order him to provide those back to my client. And if he says that he cannot because he doesn't know where they're at or that they didn't exist or something like that, that he should pay for them. With regard to the attorney fee request, again, at the core of this motion, it's really about fairness and my client's ability to be able to participate meaningfully in this litigation. The personal property that she wants you to order Mr. Zeifman to give back, she didn't want to wear that stuff around town. The only thing she wants that stuff for is to be able to feed herself, feed her kids, and to be able to participate meaningfully in this particular litigation. And the court has broad discretion under Family Code Section 6.502 to order interim fees, and we ask that you exercise that discretion. The brief that was submitted this morning in opposition to that, I just got, they cite the Eaton case, which is a Fort Worth case, 2014. It's Westlaw 4771608. I don't think applies in this case. First of all, the Eaton didn't have to do with the premarital agreement. It had to do with the postmarital agreement. And it had to do with already dividing the properties of the parties, but whether that be community or separate. There was already a determination. The parties had agreed what's separate and what's not. And so the court, in that particular case, since that issue had been determined, it was found that the court abused discretion when it ordered interim fees. Here, that hasn't happened yet. Whether or not there is a community property to divide is to be decided later. And so on the one hand, they want their cake and they want to eat it too. I mean, they say that, well, that everything belongs to Mr. Zeifman and that she signed away any rights to that stuff. But on the other hand, they want to say, but even though she doesn't have the money to participate meaningfully in this case, Judge, you shouldn't order interim attorney fees. And there is no case, and believe me, I looked hard, that would stand for that proposition. You, Judge, have the full discretion and broad discretion under 6.502 to level the playing field, or at least make the playing field a little bit more level. And that's what we're asking you to do, Judge. That's all I have. Thank you very much. I appreciate your time this morning.
All right, Mr. Burnett.
Yes, Your Honor. As counsel said, this is the second time these parties have been married. What we're here for right now is a divorce on a short-term marriage involving no children. And by way of background, in December of 2021, the parties executed a premarital agreement. And attached to that premarital agreement was detailed financial disclosures that Mr. Zeifman made to Miss Zeifman at the time. About 5 months later, in cause number D1FM 22-003807, Mr. Zeifman filed for divorce. And I requested the court take judicial notice of that file. And
I will do so.
Okay. And then before I forget, I do want to invoke the rule. They've designated Ms. Zeifman's minor daughter as a witness today. I don't think it's appropriate. We can take that up if they do indeed call her, but I want to make sure she's not present on the Zoom call.
Okay.
I'll confirm that she's not, Your Honor. And she's standing by, and when she's ready to go, we'll have her click in.
Okay. All right. The rule has been invoked. So, counsel, you're both reminded that you need to instruct your witnesses accordingly. And if any witnesses are watching on Zoom, you need to stop viewing the proceedings on our live stream. And just one other thing before we proceed any further, Mr. Zeifman, the rocking back and forth or the movement is really, I have pretty extreme motion sickness. And so if you're not able to sit still, that's fine. I would just ask that you perhaps turn off your video until you're called. I'm getting a little sick here because of this.
I apologize.
That's okay. It's just with something about being on Zoom, ceiling fans I can't tolerate, and other things like that. So you are welcome to, if it's easier, if you want to turn your video off, you may do so. You have my permission.
I appreciate it. You're not the only one who's complained.
Okay. All right, no
Thank
worries. It's just it will be easier for me to concentrate on the evidence if I'm not nauseous. So, all right, go ahead, Mr. Burnett.
All right, going back to the original divorce case between these parties in 2022. As I mentioned, they had a prenup that they executed before they got married in December of 2021 that had financial disclosures, a waiver of further financial disclosures in the prenup. I'll refer to that as the first prenup in this hearing. And then the first prenup provided that there would be no community estate, and each party waived any claims or demands against the other person's separate estate that had accrued in the past or would accrue thereafter. When Mr. Zeifman filed for divorce in May of 2022, Ms. Zeifman hired Daryl Weinman to represent her in that case. And Daryl Weinman, on behalf of Ms. Zeifman, filed a challenge, a counter petition that's in the record, rather in the court's file that you've taken judicial notice of challenging the first prenup. And she alleged that it was unconscionable, executed under duress. She also, in that case, filed an EEOC complaint against Mr. Zeifman. Mr. Zeifman had provided support to her through one of his companies. She didn't have to do any work for it or anything like that at all. But she received a paycheck and health insurance benefits through one of his companies. During that first divorce proceeding, Ms. Zeifman then filed a demand for money damages from Mr. Zeifman, claiming employment discrimination, and claiming even though she didn't do any work, that she was subject to 13 hours a day of work.
Judge, I'm going to object. I mean, this is stuff that I'm pretty sure we're not going to hear this in evidence, so I don't know what this is, and I wouldn't call it an opening. But to me, this is inappropriate. I thought we were going to litigate the issue of the enforceability today.
Your Honor, and I'm not going to go on long about this, but it goes to the credibility of Ms. Zeifman, which is right at point and at issue when we're dealing with these property claims that she's making in this case.
All right, I'll overrule, but let's try to keep it short.
All right, so she alleged sexual harassment in the workforce, all that kind of stuff, whatever. Ultimately, she got into a dispute with her first lawyer. She dropped the challenge to the first prenup, and on November the 7th, 2022, the court granted an agreed final decree of divorce in the case, confirming that there was no community estate and each party was awarded their separate property. Shortly thereafter, Mr. Zeifman was notified that Ms. Zeifman was involved in an automobile accident. I think she was driving an e-bike. There's some dispute who was at fault for that accident, but she suffered some injuries. Mr. Zeifman went to see her in the hospital. They started talking again and repaired their damaged relationship. And so about 6 weeks later, on December the 21st, 2022, the parties did two things on that day. First thing they did that morning is they executed what I'll refer to as the second prenup. That's the prenup that's involved in the present case. It is the exact same prenup that she executed a year earlier. The only difference, it doesn't have the financial disclosures attached to it, but everything else in that prenup is verbatim, word for word. And she already had the disclosures from Mr. Zeifman from the first prenup that again was executed just 12 months before the second prenup was executed, and confirmed by the court in the final decree of divorce 6 weeks before she executed the second prenup. So they got married on December the 21st with the same prenup as they had the first time around. History repeats itself. 5 months later, in May of 2023, Mr. Zeifman decided to file for divorce again. Now, this is important to keep in mind. Since they got married the second time in December of 2022, the parties never cohabitated together. She never lived with Mr. Zeifman on his property here in Austin. At all times, she had a separate residence. Of course, she would go over and stay at his place at sometimes, but she had a separate residence at various locations in Austin, Texas, that Mr. Zeifman rented on her behalf. One was at the Grove, there was another one in Clarksville, there was one off 2222, there was one in Northwest Hills. She always had a separate residence where she resided with her daughter, Vivian, who's on their witness list. In May of 2025, 2 years after he filed for his divorce, he decided to non-sue the case. And they went on a vacation that summer that did not go very well. When he returned the fall in September of 2025, Mr. Zeifman filed his third petition for divorce, which is the one we're on before Your Honor today. And he notified Ms. Zeifman that he was done this time. He could no longer do it. We don't have to get into it, but he just couldn't handle all the drama that was going on. She then went and hired counsel that's here before you today. And just like the first time, back in 2022, they allege that the second prenup is unconscionable and signed under duress. Same defense as the first time. I guess the claim is that he tricked her twice. I don't understand it. And in this case, they've alleged that perhaps she wasn't competent to sign the second prenup on December the 21st, 2022. And if that's the case, and we'll find out during the trial, as an aside, I don't know how you could be incompetent to sign a prenup, but then competent to get married. We'll deal with that before the trial judge later. But they filed that complaint at that time, that allegation at that time. That was in October of 2025 is when their answer and counter petition came forward. In November of 2025, Respondents Counsel contacted me and said that she needed to get clothing from Mr. Zeifman's properties for her and her child, Vivian. And we made arrangements last November to have that property delivered to Miss Wynn's office. And that all happened. I thought everything was fine. We're going forward, doing the discovery in the case. We arranged for depositions either in February or March of this year. And in February, the date, the month that Mr. Zeifman was notified, I received notice from Respondents Counsel claiming that Mr. Zeifman is in possession of very valuable jewelry that Ms. Zeifman claims to own that is in excess of over $200,000. That was the first time we received any notice that we were so-called in possession of this valuable jewelry. When they tried to get the close in November of 2025, there was no mention of this valuable jewelry. I mean, one of the pieces of the jewelry that they're claiming we're in possession of is supposedly worth over $100,000. Now, I think it's going to be an issue of the credibility for them as to why they would ask for a close in November of 2021, but nothing about this very valuable jewelry. I've responded to them on multiple occasions, telling them two things. One, we don't have possession of the jewelry you're claiming. 2, we have possession of some of her clothing and personal belongings that were located at a property in Sweetwater, Texas, and a property in Midland, Texas. We don't know what's in those boxes because we had someone else box up her belongings on those 2 properties owned by Mr. Zeifman. And I've told them on multiple occasions, let me know when you want to go pick those boxes up. We've also notified them that we have a piece of yellow furniture that they've inspected, and they can take it anytime they want. Thank you. And further, we have possession of an e-bike that belongs to her that they can have at any time. But all these other belongings, all this valuable possession, this jewelry, a Tiffany ring, supposedly worth over $100,000, some other ring. I mean, you look at the list, it's like astounding that she wouldn't have asked for it earlier than 6 months or 5 months after the divorce petition was filed. We don't have. And their request for relief is really premature at this time, Your Honor. That is a final order request for relief. That's an order. What they want you to do on temporary orders is to give her property that we say we don't have. And since we say we don't have it, give them money damages for this so-called lost property. You can't do that on temporary orders. That's a final order. If we've somehow stolen her property, then she needs to sue him for conversion and seek money damages. And then you have an actual trial of whether or not, and a fact finder decide whether or not he has possession of her property. And if so, what's the value of that property? And we've demanded a jury trial in this case. If she wants to claim that we've stolen her property, then that's the subject of a final trial before a jury who will decide who's telling the truth between these 2 people. That is, who has actual possession of this property. And if Mr. Zeifman does and fails to give it to her, then what are her damages? You can't do that on temporary orders. The second motion that they have deals with the interim attorney's fees. The purpose of a premarital agreement is so you don't get into these fights, okay? And this premarital agreement says that you waive and release any claims, demands, or anything you want against the other person's separate estate. And under the case law, it's clear that this premarital agreement is presumptively valid and enforceable until a court determines that it's not. Right? And what they're trying to do under this premarital agreement is have Mr. Zeifman's separate estate, because as we sit here right now, there's no community estate for either party. They want his separate estate to pay her attorney's fees. And the Eaton case says you can't do that. The Eaton case is the only case out there dealing with the award of interim attorney's fees on temporary orders in a case involving a marital property agreement. Now, Mr. Lavarado said, well, this case is different because it involves a prenup and the Eaton case involved a postnup. There's no distinction under the law. If you look in the family code, you can do a prenup and make it all separate property. You can do a postnup and make it all separate property. It makes no difference whether or not it's a prenup or postnup. And the Eaton case specifically held in that case, the trial court ordered the husband to pay interim attorney's fees from his separate estate under the marital property agreement. And the Court of Appeals granted the mandamus and overruled the trial court. The Court of Appeals held in the Eaton case, you cannot do that. You cannot divest that person's separate property to pay the wife's attorney's fees when in that marital property agreement, the wife had waived and released any claims against the separate estate of the husband. And that's exactly what we have in this case. In the second prenup that you're going to have in evidence, just like in the first prenup, Ms. Zeifman specifically agreed, no community estate, it will only be separate property of each of the parties, and there's a waiver and complete release of any claims, demands against the other party's separate estate that had accrued in the past or were thereafter accrued in the future. And so the Eaton case is right on point. Now, what counsel can do is, if he can go to trial and set aside the prenup, then you do have a community estate. And at that juncture, it might be appropriate for them to request interim attorney's fees, but not beforehand. Now, lastly, counsel said and tries to paint this picture that Ms. Zeifman doesn't have any money, is destitute, can't afford this fight. Okay, two things I want to say on that. Number one, she testified in her deposition recently that she just got a new job making 6 figures. That's number one. Number two, she testified that she has approximately $60,000, I think it was a little shy than $60,000 in her bank account. 3, Mr. Zeifman continues to provide her a salary so that she and her children, who are not his kids, by the way, can have health insurance, and he also pays for her cell phone. Fourth, and lastly, Your Honor, any fees that they do get, which are not proper under the Eaton case, but even if they were, they have to be reasonable. You have to have reasonable fees. Here, respondent's counsel has billed her almost $250,000 in legal fees so far. And my testimony is going to be, when we get to this, that is not reasonable. I've not kept detailed bills of what I billed Mr. Zeifman. I've not sent him a bill yet, but in preparation for this hearing, I've gone through and looked at what I've done and what my office has done. And my fees, when I send him a bill so far, will be approximately $30,000. $30 to $250. All we've done so far, Your Honor, is we've deposed the parties, exchanged written discovery. We haven't had any hearings before today. And so even if they can get fees, which they can't, that doesn't mean you can just get whatever you want. If counsel's owed $130,000 or $140,000, they still have to demonstrate that those are reasonable fees. And I think $250,000 in fees is unreasonable for 2 depositions, the exchange of written discovery in the case, and no court hearings. That's all I have.
Okay. Mr. Lovato, you may call your first witness.
Yes, ma'am. Thank you. Can you hear me okay?
I can, but keep the volume up.
My first witness is Audrey Zeifman.
Okay. Ms. Zeifman, if you'll raise your right hand and be sworn, do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
Good morning, ma'am. Please state your full name for the record, please.
Audrey Zeifman.
And you filed this motion today, correct?
Yes.
And you're currently married to Mr. Clifford Zeifman.
Yes.
All right. And you heard some of the opening statements here and the timelines. You've been married to him twice now, is that right?
Yes.
And the second marriage, when were you married to him, please?
The second marriage, I was married on December 22nd, 2022.
Okay. And wasn't that the day that you signed the prenuptial agreement that is in connection with the second marriage?
Yes.
Okay. Had you seen that prenuptial agreement prior to signing it on that day?
No.
How soon before you were married did you sign that agreement on that day?
I believe
In
I
other words,
signed
was
it.
it a matter of hours, minutes, days? What was it?
No, it was in the courtroom. I mean, it was in the office of the notary.
Okay. In connection with that particular agreement, was there anything attached to it that showed you what the estate was that Mr. Zeifman said that he had, or was it just the agreement itself?
No, it was just the agreement itself. I didn't remember.
Got it. And let me ask you this, are you employed now?
I'm not. I don't have a job. I did have a job, but I don't now. I am.
You recall that Mr. Burnett took your deposition about a month and a half ago. Is that right?
Yes.
At that time, was it your understanding that you were employed?
Yes, I had a contract executed and a supervisor.
What happened after that?
The day after the deposition, where I had stated that I really didn't want to reveal the name of my employer or supervisor because of past patterns of Mr. Zeifman in interfering with work. I did so anyway, and the next day, my company, everything just went away. All of a sudden, my supervisor was no longer my supervisor. They stopped communicating with me, and it's just gone.
So you don't have an income at this point from an employer, correct?
Correct. I don't have an income from an employer, although I am doing what I can. I'm cleaning houses. I'm renting my car, and I'm starting to teach a couple of yoga classes. And my daughter is working full time right now.
Okay. Ms. Zeifman, during your marriage, and let's talk about the second marriage, where did you reside?
In the second marriage, I primarily resided at the compound.
What is that? Just kind of describe what the compound is for Judge Mangrum.
It's a 20,000 square foot property with separate buildings, and I believe there was 5 properties, 5 lots purchased but that were all combined. It's a big metal fence, and the first thing that you see in the front entryway is a giant red garage, bottomless garage, top's the gym with really giant clown faces. And the entryway, you enter the kitchen, and that's where it's a 2,000 square foot commercial kitchen.
That's okay. Let me keep going because I got to get. So other than that particular residence, did you reside any other places? Like, for example, did you have other places that you could sleep at night?
I did sometimes. So yes, at times I did.
As did Mr. Zeifman, right? I mean, he had other pieces of real property that he owned that he'd go and stay overnight as well, correct?
Yes.
Okay. During your marriage, did you keep personal belongings such as jewelry and the things that we're going to be talking about today at the compound?
Yes.
Okay. Did that did that type of property include jewelry?
Yes.
Did it include gold coins?
Yes.
Did it include personal documents like passports?
Yes.
Prior to your separation with Mr. Zeifman, did you always have access to those items, or was it something that he controlled where those items were on the compound or elsewhere?
He had sole control of where my items were located.
When you say items, the ones that we just spoke about, right?
Yes.
Jewelry, the gold coins, passports, right?
Right.
Why is it that he was the one that had control and custody of those things as opposed to you?
Well, in March of 2025, he had demanded that I bring all of anything that was worth anything valuable from the safe house apartment where I stayed sometimes to him, to put in his office in a safe at Medical Parkway because we would be traveling all summer, and Bunnell was not, that property was not a safe place to keep anything valuable. As for the other, so that was the first time he was in possession of everything, all of my heirlooms.
And we're going to go through the individual items, Ms. Zeifman. What I'm really wanting to know is why was it that it was he that would have control over these items? Did he tell you that that's the way that he wanted it, or just kind of describe briefly how that came to be?
He insisted, he said, it's stupid to keep your stuff at Bunnell all summer. It's not as safe of a neighborhood. It backs up to 2222. It's easy that we don't have the security there, and it's more likely to get broken into. I have full-time security, and it's done. You need to bring it here.
Okay. I'm going to go through some items of property with you now, okay? And then we'll talk about specific pieces. I'm going to share my screen, Your Honor, if I may.
You may.
I'm looking for the AirPlay piece on my share screen to use TrialPad, but I don't see it. So I may have to have my paralegal go through this. Go ahead, Ms. Martinez, if you would put up R1. And these are all in the box, Your Honor. Ms. Zeifman, what is this that we are looking at?
That's my wedding ring that Mr. Zeifman gave to me in December of 2021, just prior to, and that I wore and had in my possession until through the second marriage in 2022.
Is this an accurate depiction of what that particular ring looked like?
SIM cards and
It is.
Okay. Your Honor, I'm going to request to move this into evidence, this exhibit R1.
No objection.
It's admitted.
Okay. And Ms. Zeifman, did you wear this ring regularly?
Yes, I wore it. I wore it every day.
Is this particular ring a ring that you have in your possession now?
No.
Can you describe it? In other words, how many carats was it? Is that a diamond? Just briefly.
It's a real diamond, and it told me it was over 3 carats. Asher cut, it has platinum band.
Okay. Go to the next page of this particular exhibit. Again, this is all in the box. Is this ring here that you're wearing the same ring that we were just looking at?
Yes.
Okay. And then this is a picture of you and Mr. Zeifman at dinner, right?
Yes. Well, it may be lunch.
Okay.
Yes.
All right, go to the next one. And is this the ring on your finger as well that looks like you're taking a picture of yourself in a mirror?
Yes.
Okay. When was the last time you remember seeing this ring?
Was in early 2023.
Do you know where it went or who took it?
I believe so. Yes.
Okay.
I know who
Tell the
took it.
court.
I was been in Portland, and where Clifford had said we were going to pick up my ring. And I said I didn't want another ring, but so I was wearing that one. And he told me that that this was my ring, but he had too many emotional he's too emotional about it, negative memories. So he was putting it into a safe at Medical Parkway and I could wear it later whenever I wanted, whenever he was healed. And so he took that from my finger and put it in a box. I don't know if he put it, I think he put it in the box that the next one came from. And he gave me the second ring on that day.
Okay, so we'll call this ring that we're talking about right now, ring 1. Was that the last time you saw it?
Yes.
Okay. Miss Martinez, please bring up R2. And if you turn to page 11. First of all, Judge, this is these are sworn up documents provided to counsel and discovery, the base stamped on the bottom right. I'm just going to turn to the relevant portion of the document and ask my client some questions. Right there. What is this document that we're looking at?
I can't see very well. Okay, hold on. This is an record of the purchase of the gifts of jewelry, that a ring and earrings that Clifford.
I specifically want to focus your attention to the top portion of the page that we're on, and there's a number. It says 861-28310. Do you see that?
Yes.
Okay.
Hold on, excuse me. What's the Bates number on this page? Okay.
Okay. You see the description, Asher 5-carat diamond GIA ...
Yes.
Okay. Is this a description of ring 1 that we've been talking about?
I believe it's the other one.
Which one?
I didn't have it appraised, but he had told me it was, he told me it was over 3 carats. So I don't know which one it was. It was the same.
Okay. Okay, you can take this down then. You indicated earlier that there was another ring that Mr. Zeifman purchased because the first ring had bad memories or words to that effect. So did Mr. Zeifman purchase another ring for you? Did you answer? Okay.
I didn't hear that.
You're cutting out a little bit. Go ahead and answer again, please.
Well, yes.
Okay. And I'm going to put up on the screen an exhibit here that is a description of another ring. Why don't you bring up R4? Okay, stop right there. Ms. Zeifman, do you recognize this particular document?
Yes.
Okay.
It was in my possession.
What is it? Does it describe ring 2?
Yes.
Okay. And see where it says shape and pedestal?
Excuse me, Your Honor. I object to counsel asking the witness any questions about this exhibit until it's admitted into evidence.
That's fine. Is this a document that you've seen before that you can verify is true and correct?
Yes.
Okay. Move to admit it into evidence, Your Honor. It's also been provided in discovery.
I object hearsay.
All right. What's the response?
Well, it goes to her state of mind in terms of what this particular ring looked like in her memory.
Expensive monthly bills are about to become a thing of the past, since free internet technology already exists.
It's not a basis to overrule a hearsay objection to an appraisal report that's not certified and does not have a business records affidavit.
I'll sustain.
Okay, you can take that down. Ms. Martinez. You recall that the ring number 2 was a diamond ring.
Yes,
How many carats was it?
same 3, a little over 3.
When was the last time you remember seeing that ring?
I remember seeing it last in May of 2023.
Okay. Tell us the circumstances of that. In other words, did Mr. Zeifman take possession of it, or what happened?
He did. He took possession of it it said he was going to clean it, get it cleaned. And so that took some time. And then we left, he filed for divorce unexpectedly, and we were supposed to leave town, and I didn't see him again. So he kept that.
Where were you when he took that ring?
I was at where all of them was in his kitchen at Churchill.
At the compound?
Yes.
Okay. Have you seen it since?
No.
Do you have an understanding as to the value of the first ring we were talking about earlier?
I was told several things, so I believe it's worth around 75,000.
Did Mr. Zeifman tell you that?
He did.
With regard to the ring that we've just been talking about, ring number 2, do you have an understanding as to the value of that ring?
I don't really know. I wasn't aware it was lab.
Okay. Let me bring up another document, Your Honor. It'd be Exhibit R3. Please present that. Do you recognize this ring?
Yes. Both of those.
Is this ring the same as ring 1 or ring 2, or is this a different ring?
No, that's a different ring.
Okay. Who took this picture? Did you?
Yes.
It accurately depicts the ring which was owned by you?
Yes.
Okay. Request
That's at the compound. Sorry.
Request to move this into evidence, Your Honor.
No objection.
Admitted.
So is this the third ring that you received from Mr. Zeifman?
Yes. You'll see below there's a band that I received, but that is the third. Diamond that I received. Mr. Burnett was there with his wife.
Objection non-responsive.
Yes.
Is Mr. Burnett and Mr. Zeifman friends, as you understand it?
Best friends.
So has Mr. Burnett been present on many occasions with you and Mr. Zeifman?
Yes, he and his wife have been present.
They've been to the compound?
They visit the compound several days a week, every week.
So is it your testimony that Mr. Burnett has seen you wearing this particular ring we're looking at?
Mr. Burnett, it is my testimony, has seen every ring that we're talking about on multiple occasions. And this ring, I know, if you see my fingers really swollen, because Clifford had ordered it
I
too
object
small.
to the non-responsiveness.
Yeah, Ms. Zeifman, I'm going to have to kind of lead you down the path of what I'm looking for. And so what's the circumstances, as you understand it, as to why you got this ring from Mr. Zeifman?
I got this ring because, again, he said that ring number 2, that he had put it in the safe with ring number 1, and that this one was just emotionally. He said that he was emotionally traumatized by that other ring as well. And so he gave me this one.
Is this ring in your possession?
No,
Where's the last place you remember seeing this ring, which we'll call ring 3?
I remember the last place was at the compound in the kitchen.
And was that with Mr. Zeifman?
Yes,
Do you have an understanding as to the value of this ring?
I do not.
Do you have any access to get this ring or retrieve this ring as you sit here today?
No,
Was this a real diamond?
it was a lab diamond.
Did Mr. Zeifman tell you how much it costs?
No,
The first ring we were talking about, ring 1, was that a real diamond?
yes,
How about ring 2?
no.
Okay, I'm done with this exhibit. If you can bring up R5. What is this?
That's a ring that I made for myself. Well, it's my diamonds. It was made at Lee Major's Jewelry, and it's all the little diamonds that my grandparents or my parents had given me over a lifetime when they could have.
So did you own this ring prior to your marriage with Mr. Zeifman? Either 1 or
Yes.
2? Yeah.
Yes.
Okay. I'm going to request to move this into evidence, Your Honor.
No objection.
It's admitted.
Did you regularly wear this particular ring, ma'am?
Yes.
Where was the last place you remember seeing this ring?
In my silver anthropology jewelry box that I took to Clifford's on March 15th, 2025.
Did you say that this particular ring was in a box?
Yes, this ring was in a jewelry box. Yes,
Okay. Did Mr. Zeifman take possession of the box?
he did.
Did he say what he was going to do with the box?
Yes, he put it under the cabinet of the stool that Bobby was designated to sit at, and he said that Thomas would put it in to the safe the next day. He would have Thomas do that.
Who's Thomas? Just briefly.
Thomas is Clifford's everything man. So he sets up all of the security. He builds some properties. He reviews the cameras. He watches us.
He's someone that's employed by Mr. Zeifman. Is that your understanding?
Yes.
Okay. Do you have an understanding of the value of this ring?
Yes.
What is it?
It was appraised at $75,000.
Can you bring up R6, please? Do you recognize this?
Yes.
What is it?
It's a band. Can you hear me?
Yes.
Okay. It's a wedding band that from a previous marriage that doesn't have a stone in it.
Where's the stone?
It fell out. It was a blue stone that fell out when in Clifford's home somewhere.
Okay, this isn't something, the stone isn't something that you're saying then is in Mr. Zeifman's possession or that he took that, are you?
No, I'm not saying that.
But the
fell out.
ring, the band itself is, correct?
Yes,
Okay.
yes.
And then the last place you saw that was with Mr. Zeifman?
Yes.
Okay. Do you know what the value is of this particular band?
I can't say for sure. It's a lot. It's
Do you have an estimate of what it is? Do you know how much you paid for it or how much somebody paid for it?
my estimate is about $30,000, $20,000.
Okay. What are you basing that on, ma'am?
Well, it's heavy, it's for platinum, and it has many diamonds all over it, different sizes. So it's not just pave, it's 1 carat diamonds as well, half carat. Actually, half, yeah.
Okay, let's
It
go
was
to that's okay. Let's go to R6A.
and actually it was Ella's. I don't know. I'd given it to Ella.
Well, actually, strike that, Ms. Martinez. If you could go to R7. Sorry. What is this?
That is my late grandmother's gold bracelet with diamonds on it that she gave me as my inheritance.
Okay. So this was something that you received from your grandmother in inheritance. Was this prior to your marriage with Mr. Zeifman?
Oh yeah.
Okay.
Yes.
Where was the last place you remember seeing this?
In the jewelry box with Mr. Zeifman on March 15th.
Okay.
20.
Is this true and correct, accurate depiction of what that bracelet looked like, ma'am?
Yes, and it's 12 point something 6 ounces of gold.
Okay. Do you have an understanding of what the value is of this bracelet?
Yes, I mean gold was what it is 5, it was 6, but
How many ounces did you say it was?
12.6.
Okay.
Heavy times 6.
Okay.
So
okay. And you don't have access to this bracelet, correct?
no.
Okay. I'm going to request to move this into evidence, Your Honor.
No objection.
Admitted.
Let's go to R8. What is this that we're looking at?
Those are 1 ounce gold coins. Except the other one is half an ounce, the one you see. My granddad gave those to me every year. My sister for all through my childhood.
Okay. I'm going to request to move this into evidence, Your Honor.
No objection.
Admitted.
Where was the last place you remember seeing these?
In the silver jewelry box on March 15th, the compound.
And was it in the possession of Mr. Zeifman?
In the possession of Mr. Zeifman. He closed the box, put it in his hands. Yes.
Thank you. Ms. Martinez, bring up R11. What is this?
It's the silver jewelry box anthropology I had before it conferred. And it's the last time I saw my jewelry was in that box. What is it?
Okay. Is this the box that you've been referring to when you've described where the pieces of jewelry we previously looked at were located?
Yes, it's one of them. It's the main one.
Got it. And in this particular picture, is this an accurate depiction of what you remember? Did you, strike out, did you take this picture?
Yes, I did.
Okay. So it's an accurate depiction of what you remember when you took the picture, correct?
Yes,
That's okay. Request to move this into evidence, Your Honor.
yes, that was all in it.
Any objection?
No objection.
All right, it's submitted. We need to go ahead and take our morning recess. I think court reporter's been on the record an hour and 45 minutes. So we're going to reconvene at 11.
Sure.
Your Honor, if we can get an idea at some point how much time counsel has used so far, because I assume we're each allocated half to 3 hours today.
That's correct. You'll each have an hour and a half. And Mr. Loverado, you're at 41 minutes. And Mr. Burnett, you're at 21 minutes.
Thank you, Judge.
All right. We'll see you at 11. You're welcome to turn off your video until then. Thank you. See if everybody's back. We need to make sure our court reporter's here. There she is. Okay. Mr. Loverado, you may continue.
Thank you, Your Honor. I think we were looking at that silver box. If you can bring up R11 again, please. Judge, I'm going to request to move this into evidence.
No objection.
It's admitted.
Ms. Zeifman, where was the last place that you saw this box? You're on mute.
The last place I saw it was with Mr. Zeifman in his kitchen.
Okay, did the box have the contents that we're looking at within it?
Yes.
Okay, tell us the circumstances of when and where the last place you saw it.
The circumstances were that he had told me to bring all of my jewelry to Churchill, to him, where he would put it away. So I handed it to him. And
okay.
Yeah.
And we're looking at this box. If you look at the top left, there's some coins in it. You see that?
It's
okay. Are those the coins that we were looking at earlier?
yes.
Okay.
And then it also in that rusted box.
I'm sorry?
Also in that rusted box, the
Okay.
middle one.
What is your estimate of the value of those gold coins?
7 ounces, 0.5, $35,000.
Is that based on the current price of gold?
Yes, unfortunately.
And do you have an estimate as to the value of that bracelet?
Yes, it's about $75,000.
Is that based on the fact that it's gold and has diamonds?
Yes,
And did you say how many ounces that was?
12.67.
Do you know where that box with the contents is today?
The last time I saw that box was in Churchill in Mr. Zeifman's hands.
Okay.
He told me it was going to Medical Parkway.
Got it. Let's go to R12. What is this?
That is, believe that's the little brown tree box. See the Megillah there, and a couple of pieces of jewelry that were in it. One is just a big, just round stones. That's worth maybe $500. Was paid at an auction, and the small one there is a dainty. It's a vintage jewel necklace that also I purchased at an auction for $3,500.
Okay. The box that we're looking at with the contents on top, is that an accurate depiction of what you saw when you took that picture?
Yes.
Okay. Request to move this into evidence, Your Honor.
No objection.
R12 is admitted.
The lion pendant there, do you have that in your possession?
I do have that in my possession. I took that one. He said I could take that one.
Okay. What's the circumstances of this particular box being in the possession of Mr. Zeifman, if that's what you're saying?
Same as the silver. I brought it at the same time. He wanted all of my nice jewelry.
Have you seen it since?
No.
You can take this exhibit down, bring up R14, please. Okay, this is the passport of, I guess this would be of your daughter, concerning your daughter, correct?
Yes.
Do you have this in your possession?
No.
Do you know where it last was?
In Clifford Zeifman's possession.
Okay. Does he have your passport?
He does.
Have you asked for these passports back?
I have.
And what were you told?
I wasn't told anything directly. I don't have them.
The last person that you saw them with was Mr. Zeifman?
Yes.
Okay, you can take this down. I'm not going to move this into evidence.
In fact, he took the picture. So.
He took the picture that we were just looking at of the passport?
Yes, he texted it to me. It says from Clifford.
With regard to the passports, who usually maintained possession of them?
Ways Clifford maintained possession.
So did you all travel together, take vacations where you went abroad?
We did.
And when you did that, would Mr. Zeifman be the person to hold on to those and secure those?
Yes. Yes. At one point, it was really scary because he ran out of a hotel with all of our passports. But yes. And he would also have them in his possession when we went to Washington in case we went to Canada.
Okay. Ms. Zeifman, after you were separated from Mr. Zeifman, have you been back to the compound?
No, I haven't
Okay.
been
Have you
allowed.
had any access to any properties owned or controlled by Mr. Zeifman?
No,
Have you ever been allowed to conduct any kind of search regarding the items that you're asking this court to give back to you?
never.
Mr. Burnett, in opening, mentioned something about a yellow piece of furniture. Do you know what he's talking about?
Yes.
What is that?
It's an armoire I'd had for a long time that I didn't want to, there was donated everything of mine, or but I asked that that be stored because my daughter wanted it.
Okay.
And it's been shipped somewhere
Do
recently.
you have an understanding as to whether or not we've gone over to look at that piece of furniture?
We have not.
Well, last week we did, but maybe you weren't aware of that. Are you now
We didn't.
learning?
Yeah, we didn't go to Riesel. Maybe I misunderstood. We didn't go to Riesel to look at it all together. Did you mean?
Yeah, that's okay. As far as you know, when we went to look at this piece of furniture, was there anything in it?
No.
Okay. Is it pretty worthless piece of furniture or what?
No, it's not.
Okay,
No,
tell
it's not.
us what it's worth.
It's an Adele Kerr armoire that I got in Highland Park. It's worth $10,000.
Ms. Seifman, you're asking the court to return items of property to you, such as jewelry and things like that. Are you asking the court to do this so you can wear them around, or what's the purpose of your asking?
No, I'm asking for them so that I can pay my fees and I can get a divorce. I can't afford a divorce.
And are you currently experiencing financial difficulty at this point in time?
Extreme financial difficulty.
Have you
have you been able to pay us your attorney fees?
Only a portion, but
How
no.
much?
I've been able to pay about over 70,000.
Is there an amount still due and owing to us?
Yes, some
How much?
140,000.
And as you understand it, a major part of this case is whether or not the prenuptial agreement that Mr. Burnett was talking about earlier is enforceable or not, right?
Right. Right.
Would the return of jewelry or an amount of money for their replacement help you in supporting yourself and participating in this case meaningfully?
Yes, I can't continue if I don't have get my jewelry back. I can't continue.
Did you say that you're doing things like, for example, cleaning houses to make ends meet?
Yes, I am, and my daughter's working.
I'm sorry?
My daughter's working too.
How much are you asking the court to award in interim attorney fees?
Well, I leave that into the court's discretion. But if I owe you $140,000, I would say at least that amount.
And are you asking that the court order interim attorney fees prospectively? In other words, to the extent that we have attorney fees going forward to help you with your claims? Sorry?
Yes.
Your Honor, I'll pass the witness.
All right, Mr. Burnett.
Ms. Seifman, you have a college degree, correct?
Yes.
And you're a licensed therapist by the state of Texas, is that correct?
Yes.
Are you working as a therapist now?
I am working. I have 2 clients that I talk to once a month.
So you work a total of 2 hours a month as a licensed therapist, is that right?
4 hours a month. My data was all breached by your client, so I can't.
Objection, non-responsive. Just try to answer my questions. We went through this in your deposition. Just answer my questions, ma'am. You work 4 hours a month and you're a licensed therapist with a college degree, correct?
Yes.
Okay. And when I took your deposition last month, you had approximately $55,000 in your bank account, correct?
Yes.
And you testified that deposition that you just got a new job making 6 figures, correct?
Yes.
And Mr. Zeitman was not at that deposition, was he?
No, he was not in person.
All right, thank you. All right, thank you. And do you remember at the deposition, I asked you if you had any written documents showing that you were offered this job for 6 figures and you'd accepted? You remember me asking you that question?
Yes.
And you remember you testified that you did have documents supporting that. You remember that?
Yes.
And I asked you if you would produce those documents to me, and you said you would, correct?
Correct.
All right. As we sit here right now, a month later, you still have not produced any documents to me showing that you were offered this 6-figure job and you accepted it, correct? Yes or no?
A correction?
Have you produced those documents?
I
to me?
haven't.
Yes or
I haven't
no?
produced documents to you, to my knowledge.
Okay.
All right.
Well,
The court reporter is waving. She's very frantic and upset with all of you. You need to speak one at a time. She cannot take more than one person speaking at a time. Thank you.
why have you not given me those documents that you agreed to do so a month ago?
I wasn't aware that you did not have them.
Whose house are you cleaning now?
I'm cleaning for a service that where I clean several houses.
Okay, how many houses have you gone to clean since I took your deposition 1 month ago?
I just got hired, so only one. And
okay, because you testified that you testified that you're cleaning houses to support yourself, correct?
Yes.
And is it your sworn testimony that you have now cleaned one single house? Yes or no?
Not by myself, but yeah, I'm having to shadow.
Okay, where was that house located and when did you participate in the cleaning of this house?
My Joy is who my new boss is, and I showed her by cleaning her apartment because we live in the same area, and so I didn't get paid for that. But I only got this position last week.
Okay, ma'am, what's the name of this cleaning service you now claim to work for?
I'm going blank. It's I'm sorry, I'm drawing a blank. Can I pull a card out to show you, or
Sure. Pull the card out and tell the court the name of the cleaning service that hired you to clean homes.
okay, it's I don't want to take up time. Can I get that to you at break, please?
That's fine. I think we understand what's going on. Now,
I
isn't
have
it
it.
true, ma'am? Ma'am, you've not cleaned any homes, have you?
Yes, I've cleaned her home
Okay. Okay.
yes,
Is the home you're saying you cleaned your employer's home?
yes,
Okay. And the lady who owns the cleaning company, you went and cleaned her house?
her apartment. Yeah, to train. I'm in training.
Okay.
So
what is that lady's first and last name?
she just moved in. Her name is Joy, and I'm drawing a blank. I can't look at my phone, right?
No, can you remember her last name?
Not this moment. I'm flustered.
What does she look
But
like?
I have her phone number. She's 60. She's in her 60s, and she has gray hair, and she lives in my complex.
And so how did you meet this lady?
At the swimming pool at my apartment complex. She said she had a small cleaning business, and I asked her if she needed any help, and she said yes. And she said that she had one of her cleaners was not able to clean anymore, and so I would be training under Maria, who's our longtime cleaner, and that I would be assigned clients, and if I could find clients, that I would have be able to use those two, and if they book 3 times, then I would get $50 referral fee.
Now, you and Mr. Zeifman got remarried for the second time in December of 2022, correct?
Yes.
And since that time, you've always had a separate place that was leased for you in Austin, Texas, correct?
Clifford and I have had.
Objection non-responsive. Try to answer my question.
Because no, I am.
Yes or no? Since December of 2022, when you got married for the second time, you've always had a separate residence in Austin leased on your behalf, correct?
No.
Okay. When did you not have a separate residence since December of 2022?
I did not have any separate residence. Clifford was on a lease, or he owned the property. And when I was on a lease in 2 places, he threatened to, sometimes he wouldn't make the payment. He'd take himself off, and I couldn't afford to stay there. I didn't have anything or anywhere. And
okay, let me try to simplify
witnesses can tell you that the apartment complex, my landlord.
All right, let me try to simplify this for you now. Since December of 2022, isn't it true that you've always had another place in Austin where separate from this so-called compound that you call it, where you had a key to the front door where you can enter that place? Yes or no?
Aside from sometimes, but yes.
Okay.
I have, yes.
Okay. And it's your testimony that in March of 2025, when you previously testified you were living in the compound, Mr. Zeifman told you to bring all this valuable jewelry from your residence on Bunnell Drive to his place. Is that what you're telling us?
Yes.
Okay. Well, if you previously testified you were residing in the compound, if you're residing in the compound, then why did you have all this very valuable jewelry in this residence leased for you on Bunnell Drive?
Well, it was purchased by Clifford, so it belonged to him too. It didn't belong to me. And when I had, he didn't like it when I had it at the Grove as well. My jewelry that was separate than what he had given me, and so he kept kind of pushing, but the Grove was safe, and so I moved everything to Bunnell, and we were moved around 6, 7, 8 times. And he brought it up. So like, bring it over. It's not really safe there, but I was there. I was living there a lot. I was there, wasn't in the daytimes, but we slept at Bunnell a couple of nights a week. And so he asked me, and when he finally said in March, this all needs to be secured in my office at Medical Parkway. So that's why.
Well, if you're living, my point is, ma'am, if you're really living at the compound, why did you ever even take all this jewelry that you claim is worth over $200,000 to this residence on Bunnell Drive? Why did you do that?
First, I took it to Riker. I had it in my possession the first time that he surprise divorced me. And then I moved it to the Grove, to Riker. These were safe places. And then when I moved to Bunnell, it wasn't, according to Clifford. Is that your question?
Now, no, I don't think you can answer it. But this Bunnell residence that you're talking about, that's the residence that was on your daughter's school records for where she resided, correct?
No.
What residence? Your daughter goes to Anderson High School, correct?
Yes.
And Mr. Zeifman, the compound is not within the Anderson High School school zone, is it?
The compound is not.
Right. So what address did you use for your daughter to be able to go to Anderson High School?
Mr. Zeifman provided me with a lease for Quarry Lane, which is where Quarry Lane, something he owned, and he gave me a lease to sign, and that's what I presented.
Right. Now, this residence, Bunnell Drive, where you say all this valuable jewelry was at until March of 2025, had a security system, correct?
Oh, yes, it did.
Right. So this unsafe place had a security system through ADT, correct?
Yes.
And it also had Ring cameras, correct?
Yes.
Okay. Now, Mr. Zeifman filed for divorce I guess the third time now, in September of 2025, correct?
Yes.
All right. And the first time you ever made a claim or demand for the return of these items that we're talking about today was in late February of 2026, correct?
Incorrect.
Well, what records do you have where the demand was ever made before February of 2026?
Well, I have records of that I sent everything. I sent all of my jewelry that was missing at the same time that I sent everything, my clothes. So I sent it all at the same time. But since I didn't have anything to wear and it was cold, the immediate focus was we need our clothes.
Objection, non-responsive. Isn't it true, ma'am, that the first time that your lawyers gave me a written notice that Mr. Zeifman was in possession of this valuable jewelry you're talking about was on March 2nd, 2026, correct?
I do not know. I provided my lawyers with the information in October of 2025.
Okay, well, if you look at petitioner's exhibit number 9, you recognize these emails between your lawyers and myself? If you can share the screen, Ms. Young.
She can share.
You're on mute.
Pulling it
Can
up.
you share yeah, petitioner's exhibit number 9, and if you go to the 3rd page of this email.
Your Honor, I might have missed something, but I didn't see any exhibits provided in connection with this hearing from petitioner.
Yeah, we loaded them in the box this morning before the hearing began. All right, do you see that email there?
Yes.
It's to me
Mm-hmm.
from your lawyer, Ann Wynn, correct?
Yes.
And what is the date of that email?
It's hold on, I'm trying to see the date. I'm sorry.
I'll help you out. You see where it's dated November the 11th, 2025.
I just scroll down. I don't see. Okay.
It's right there.
Okay.
Your Honor, I'm going to object this hearsay.
Well, I don't think he's offered it yet, so.
I'm just objecting to him asking questions, but that's fine.
Do you see the date of this email, November 11th, 2025?
I'll see where it is, where the date, it says the date.
Okay. Your Honor, I'm going to offer these emails into evidence.
It's hearsay, Judge.
That's fine. I can call Miss Wynn to testify that they would really want me to do this.
Well, then, I can call you to testify because you're a fact witness in this case big time. So I didn't think we were going to go there, Mr. Burnett.
Well, I mean, you're objecting to hearsay emails that I get from your office asking for her belongings.
Judge, it's hearsay and it's documents that my client's not even on. So
I'll sustain the objection.
Isn't it true, ma'am, that last year in 2025, you're not aware of any written demands from your lawyers to me asking for any of this jewelry back, are you?
I was under the impression that there was a demand to you.
Okay, and have you seen that demand?
No, I just have provided the information.
Okay, so when you're under the impression that the demand was made to me, are you just guessing?
No, I was told that to send everything that was missing. And so I did. And then I was told that the first focus was going to be on getting us some clothes to wear.
Right.
We didn't have anywhere to live either.
Did you have a chance to read your lawyer's first amended motion to compel that this was filed in this case?
Yes, I believe so. Yes.
And did you see attached to their motion as Exhibit A, an email from your lawyers to me on March 2nd, 2026, demanding the return of this jewelry that we're talking about today?
Yes.
All right. Have you personally seen any written demands that predate March 2nd, 2026? Yes or no?
No, just mine.
Okay. And just yours, to be clear, your communications with your lawyer, correct?
Yes.
You don't have any written communications from you directly to Mr. Zeifman demanding the return of any of these items, do you?
I do, but not.
All right, where are those communications? You're under oath, ma'am.
Office. They're with my attorney's office.
Okay, so are you testifying under oath that you have a copy of communications, either emails or text messages, from you to Mr. Zeifman since March of 2025, demanding the return of these items that you say you left at his house? Yes or no?
I have Yes, I have communicated that I want those items back to him.
And did you communicate that in writing is my question.
Yes, and texts and yes.
Okay, why haven't you produced those text messages?
I am happy to. I don't.
Truth is, you don't have them, do you?
No, that's not the truth.
Okay. It is true that you've had your own safety deposit box at Chase Bank, correct?
No, I had one.
Okay, since December of 2021, when you married Mr. Zeifman for the first time, have you ever had a safe deposit box at Chase Bank? Yes or no?
I believe it was closed the next month after we married. He said it was too expensive. I couldn't afford it.
You think it's strange that you got these pictures of this jewelry in your jewelry box and you with a ring out like that? I mean, do you think that's odd?
How do you mean?
Well, do you think most people go out and take pictures of their jewelry boxes that they have?
I don't know. I take pictures of everything. And is it odd that I took pictures of my jewelry box? Is it with jewelry? No. I like to, it's important to stay organized about what I have and where it is. So, yeah, no, I don't think it's odd at all. As far as on my hand, took a picture to send to someone to show them.
All right. Response exhibit number 1 was a picture of the ring that you claim Mr. Zeifman has possession of that's worth how much?
$75,000.
Okay. And you testified that the last time you saw this ring was in early 2023 when you were in Portland with Mr. Zeifman, correct?
Yes.
Okay. Isn't it true, ma'am, that you've only gone to Portland with Mr. Zeifman one time in your life, and that was in December of 2021?
No.
How many times have you gone to Portland with Mr. Zeifman?
I've driven through to take his kids to camp. We've I don't know, maybe 8, 10. We went to look at some property. He bought a trailer home park. And this trip I was suffering from a concussive disorder. I hadn't even started physical therapy yet.
Are you testifying under oath that you've taken more than one trip to Portland with Mr. Zeifman?
Yes.
Okay. Now, the other diamond rings that you've talked about were lab rings, correct?
Yes.
Okay. And a lab is a human-made diamond, correct? And in fact, the second ring you had was a 10-carat lab ring that he purchased at your request, correct?
Not the second ring I had. And it's 9 carat.
9
It's the
carat.
last one. It's the one I still have in my possession. Yes.
Okay. But the first ring you said was worth $75,000. The second ring, that was a lab ring, correct?
Yes. I didn't know it, but yes.
Now, the exhibit number 7 is the bracelet, correct? You remember that?
My gold bracelet?
Yes.
I don't see the exhibit, but yes.
And that bracelet has little diamonds on it, correct?
Right.
And how much is that bracelet worth?
It's worth depends on how much gold is worth, but, you know, $40,000.
And you do you have an appraisal for 40,000 or is that just your guess?
I have an appraisal, the original appraisal from my granddad giving it to my grandmother with, and so I had that reappraised based on that.
That's right. And you testified that you inherited this bracelet from your grandmother, correct?
Yes.
Correct?
Correct.
And it's your sworn testimony that the last time you saw this bracelet was in March of 2025, correct?
The last time I saw that bracelet was in Mr. Zeifman's possession.
And that was in March of 2025.
Yes.
Okay.
Correct.
Isn't it true, ma'am, that your grandmother died just 2 months ago?
Yes.
All right, so you
No,
inherited
not
this
2 months
bracelet.
ago. I'm sorry. She died she died a few months ago, like April.
She died after you supposedly took this bracelet to Mr. Zeifman's house in March of 2025, correct?
Yes.
So you inherited this bracelet before she died? Is that your sworn
Yes.
testimony?
Yes, she gave it to me. She gave every one of us, the cousins and my aunt, something special from something that my granddad had given to her. She's in her 90s, that she wanted us to have. She gave it to us years ago. I didn't just get it.
Yeah.
So,
Now your daughter's passport, Vivian's passport, it's true that she's not been to Washington State at Mr. Zeifman's home up there in a long time, correct?
correct.
I mean, how many years has it been since your daughter Vivian has been to Washington State?
Couple.
Well, in
No.
2000, she didn't go in 2025, correct?
No.
And in 2024, she went on some international trip paid for by Mr. Zeifman, correct?
Yes.
Okay. And so she didn't go to Washington State in 2024, did she?
I don't know. I can't recall. We were around a lot. We were supposed to go, then not. I don't recall.
Now, when your lawyer sent the request for your clothes and other items, Mr. Zeifman had 5 or 6 boxes of items delivered to your lawyer's office, correct?
Yes.
And since that time, he has told you that any belongings you had and properties he owned in Sweetwater and Midland have been boxed up, placed in storage, and you can get them whenever you want, correct?
No, I've been told that in writing by him that I'm not to approach any of these properties, not to step foot on them, including for my grandmother's funeral.
Well, are you aware of, have you received copies of the course of the several letters I've sent to your lawyers saying, let me know when you can want to go pick up those items in Midland? Have you seen those documents?
I'm aware that they were sent, but again, I'm not allowed to be on the premises, and he calls police. So,
well, sure, but you understand it's something that your lawyers can arrange for you to get, just like they arranged for you to get items last November, correct?
my items last November were,
Right.
we want to discuss what those were?
No, I just,
I'm
that's
sure you
not my, hold on, ma'am, that's not my question.
That's animal
My question is when your lawyers have asked me to get you items that we have, I've accommodated that, correct?
You have not.
Well, we had boxes of your stuff sent to your lawyer's office last November, yes or no?
Some of it was my stuff. Some of it
Yes.
wasn't.
Oh, okay, well, there were boxes of items sent to your lawyer's office last November.
There were boxes
correct?
of items sent to my lawyer's office, yes.
All right, and your lawyers asked if they can go to Mr. Zeifman's office building to examine this yellow piece of furniture. You're aware of that?
Okay.
And you aware that your lawyers went over there, set a time with me, and went over there and looked at it? Are you aware of that?
I just don't recall this time.
Are you aware that I've told your lawyers they can get that piece of furniture
Yes.
anytime they want?
Yes. Yes, I am
Okay.
aware.
Okay, and as we sit here right now, you haven't done that yet, have you?
Well, I can't afford, I don't have any money to have it put anywhere. I don't
Well, you
know.
had, a month ago, you had $55,000 in your bank account.
Sure. That's all I have. That's
Okay.
everything. It's
And-
everything. I don't have everything was taken. My daughter's college account. Poof, it
Objection
just went away.
non-response.
He took it away.
Sustained.
Mr. Zeifman didn't take your daughter's college account, did he?
Yes, he
Remember,
did.
you're under oath.
I remember. So are you.
All right, look at exhibit number 4, petitioner's exhibit number 4. Have you seen a copy of this letter that I sent to your lawyers on March 17th, 2026?
Yes.
All right, and you see where in that last paragraph, I notified your lawyers you do have some personal items in Midland and Sweetwater which have been placed into boxes. You read that, didn't you?
Yes.
And then I said, please let me know a date and time for when your client would like to retrieve these items, correct?
Yes.
And as we sit here right now, you've not taken any effort to obtain those items, or whatever is in those boxes in Midland, to get them back, have you?
Your Honor, I'm gonna, let me make my objection, ma'am. I'm gonna object on the grounds of relevance, and also this largely lacks foundation unless he's trying to say that some of these items I'm requesting are in these boxes. What's the relevance?
Well, the relevance is that.
I'll overrule the objection.
Okay. Go ahead, ma'am. As we sit here right now, have you made any effort to get those boxes from Midland? Okay, what have you done? Tell me.
Yes. Right before my grandmother died, and then when she did die, she had asked us to host her, the people, the family and friends who went to Sweetwater for her burial at our house, at our home there. And I asked to please have access to the house and to retrieve her pictures and her things. And I was told, or through you, my attorneys, that I was not to step foot anywhere near the property. And I also asked the caretaker, Vivian, if she would be able to get some things out. And she called Mr. Zeifman and he said,
I object to the hearsay. You're not allowed to testify what someone else said.
I tried. That was my try, and that's what I heard.
Isn't it true, man? The deal you're talking about now is you wanted to go spend the night in Mr. Zeifman's property out there, and he said, you're not going to spend the night in my property. Isn't that true?
No.
All right. Look at it, petition exhibit number 5. Did you get a copy of this letter that I wrote to your lawyers on June 15th?
Yes, I did.
And in this letter, I've said again, if you want your stuff in these places, just let me know, correct?
You sure have.
Are you aware of any communications in writing from your lawyers to me responding to these offers for you to go get your stuff?
I don't believe these are offers, but no.
Okay.
Also, the Cadillac. Okay.
Excuse me, you need to wait for my question. So these, adding up the values of these items, there are over $210,000 of items that you claim Mr. Zeifman has possession of, right?
Yes.
Okay. And you didn't demand these requests until 5-6 months after he filed for divorce. That's correct, right?
I answered your question.
Now, in this case, you're challenging the prenup, is that correct?
In this, yes, I am.
Right.
In this,
And-
this,
and-
not
and-
this today, yes,
Right, I understand, but in this pending divorce case, you're challenging the prenup, correct?
yes,
And the first time you got married to Mr. Zeitman was in December of 2021, correct?
correct,
And he sued you for divorce 5 months later, correct?
yes,
And in that first divorce proceeding, you hired a lawyer to represent you, and her name is Daryl Wyman, correct?
Clifford and I agreed on a lawyer to not to divorce for a divorce, but to help us reconcile what he said was an indefensible prenup that a marriage wouldn't work with something that unconscionable, and that he only had it in place because we did it like the day of, and he never thought that he would want to divorce me.
Objection non-responsive. Ma'am, the court has taken judicial notice of that first divorce case, which means the court knows what's in those pleadings in that case. You understand that?
Okay,
Okay, and in that first case, you were represented by Daryl Wyman, correct?
yes,
And I represented Mr. Zeitman in that first divorce case, correct?
yes, but Mr. Zeitman
Excuse
approved
me,
of
you
Daryl
just got to
Wyman.
answer my question. And in that first divorce case, Miss Wyman filed a challenge to that prenup on your behalf, correct?
Yes,
She alleged that the first prenup was unconscionable and you signed it under duress, correct?
yes,
Okay, and that's the same allegation you're making for the second prenup in this case, correct?
yes, but also
You've answered my
forgery.
question. You've answered my question. And
Well,
in this,
no.
well, are you challenging the prenup in the present
I
case?
am.
Okay,
I
on
am.
what basis?
On those that you said, the unconscionability and the I'm also challenging it on the basis of it's not my signature on a lot of the document. It's not valid. I didn't there are pages I didn't initial, and there were amendments I didn't see, and I didn't know I didn't have that. I wasn't under the impression that I was signing a prenup.
Not only are you college educated, but you testified in your deposition last month that you completed a year of law school at SMU, correct?
Yes.
And in fact,
25 years
you've
ago.
you've been tested in the last couple of years where it is shown you have a very high IQ, correct?
I do.
In fact, I think according to one of the tests, your IQ is in the top 5% of all people in the United States, correct?
Well,
Do you remember that test?
Clifford's
I
had me
didn't hear
tested.
that.
All right. Well, look at exhibit number 3. Petitioner's
Okay.
exhibit number 3.
Michael, it's fine. I'm sure that's an IQ range. We don't, sure.
Those are the questions.
Well, look at exhibit number 3. This is the second premarital agreement that you've executed, correct?
Yes.
And if you go to page go to page 20 of 21. That's your signature, correct?
That one is.
Right. And if you go to the next page, it's notarized, correct?
Yes. My
You
signature.
signed this contract before a notary on December the 21st, 2022, correct?
I signed some of it. And I was on hydrocodone and sumatriptan, and I had a concussive disorder. I was I knew we were getting married. I didn't, he had said he was doing everything differently, and I wasn't. I didn't know. I thought these were marriage papers, but no, I didn't sign certain pages on here.
Well, you represented in this agreement that you had an opportunity to read it. You remember that?
The opportunity? No, the day that he decided we were going to get remarried, all I remember is a text where he said he was on his way to pick me up, and he sent some kind of document, and then picked me up and drove me to, it was not Bastrop. He drove me to Hayes County, and I was on a walker. And on that ride to Hayes County, he said this was all, all going to just be really different. He messed up the first time, and he was so sorry. And then when we got there, there were papers to sign, but there was no, we didn't talk about them or anything.
Well, look at page 19 of this document. And Your Honor, I need to offer this into evidence.
What's the exhibit number?
3, petitioner's exhibit number 3.
Any objection?
No objection.
Admitted.
Look at page 19. You see all those representations that you made?
Uh-huh.
You represented that you entered into the agreement voluntarily. You see that, B?
I do. I recall standing on my walker and having to sit down and just initial. So yes, I see that.
Okay.
You reached an hour, Mr. Burnett, just so
Okay.
you know.
All right, thank you, Your Honor. And then did you also understand that, or you do understand now, that in this agreement, you waived any claims you would have in the past or in the future against Mr. Zeifman's separate estate? Do you remember doing that?
I do not remember doing that. I am aware of that now.
Okay. And this prenup is substantially the same as the prenup you executed in December of 2021 that you claimed was unconscionable, correct?
Yeah, correct.
I mean, the first prenup is exhibit number petitioners 1. You can put that up, Ms. Young. You see that?
The first one that I signed in your office a few hours before our wedding, you mean?
Right. And do you remember signing this?
Yes.
In fact, do you remember telling me that you would sign a prenup that was on a blank piece of paper? You didn't care. You just wanted to be with Mr. Zeifman, and you didn't care about his money. Do you remember saying that to me?
Yes.
You remember sending me a text? So you remember saying that? And if you look at petitioner's exhibit number 1 on page 17, that's your signature, isn't it?
Mr. Zeifman told me something different. That's why I said that.
Excuse me, just answer my question.
Yes,
is that your
that's my
signature on page 17 of petitioner's
It is.
exhibit number 1? Your
Yes.
Honor, offer of petitioner's exhibit number 1.
No objection.
Admitted.
Can everyone please not talk over each other, especially with Zoom? We need a little bit of a break, please.
My apologies. Now, on petition, Your Honor, is exhibit number 1 admitted?
It was.
Okay, thank you. And petitioner's number 1, the first prenup had detailed information attached to it about Mr. Zeifman's assets and the values, correct?
Yes.
Okay. And you read that information before you got married to him the second time, correct?
No, I hadn't read it the first time.
Okay, so is it your testimony that when you're going, after you executed the first prenup and you're going through the divorce in 2022, when you were challenging the validity of that prenup, that you never read the document? Is that your testimony?
Yes, a couples counselor told me to go read it and gave me safe place information. And that was in February of 2020.
I just want to make sure the court understands your testimony. It's your testimony that you never read the first prenup that had all these waivers, disclosures, and releases before you challenged the validity of the document in court filings?
No, I had read it.
Exactly, that's
didn't.
my point.
No. I'm
Let me
trying to answer your
let me make
question.
sure you're not. Isn't it true, ma'am? Before you executed the second prenup, that is substantially the same as the first prenup, you had read the first prenup, yes or no?
Yes.
Thank you.
That was the whole
You've
point of
answered my
contention.
question. Objection.
Why we divorced.
Sustain.
You know, I need to reserve the rest of my time. I'll pass the witness.
Okay. All right, this is probably a good time for us to go ahead and break for our lunch recess. Normally we reconvene at 1:30. Does that work for everybody? Is there a reason for us to reconvene any earlier than that?
1:30 works for me, Your Honor.
Whatever you tell me works for me.
Okay. All right. And you've used an hour and 4 minutes, Mr. Burnett, and Mr. Laverato, you are at 52 minutes.
Got it. Thank you, Judge.
Okay. We will take our lunch recess. I'm going to reboot my computer because I'm having a few issues, so don't be worried if I'm not on. You're welcome to stay logged on or to log back in at 1:30. Either way, we'll see you then. All right?
All right. Thank you, Judge.
Thanks, Judge.
Thank you, Your Honor.